Well, hello, everybody, and welcome back to Raw Law Unfiltered with your host, the DUI Guy Plus. Today, we are going to be delving into something very, very special, something that everybody has been waiting for a very long time, originally scheduled to have been submitted on November the 2nd. That's when Johnny filed his brief and his appeal. And as we learned since then, Amber asked for an extension. She asked for a 4-week extension. Ben Chu objected, and the court granted her 3 weeks instead of the requested 4 weeks. So we were able to get our hands on the brief from the Amber Heard versus Johnny Depp. See, the parties are flipped. And the reason for that is because Johnny won on his portion of the 3 statements that the jury found Amber liable for defamation on. And she's appealing those 3 statements in the Court of Appeals. So she was supposed to file the brief on November 2nd. It was eventually filed on November the 23rd, which was a Wednesday before Thanksgiving. And she filed it late enough in the day to where we were not able to get our hands on it. But now that it's Monday and we're back in business, shout out to Laura B., who was able to get the brief literally minutes before I got it. Yeah, let's dive right into it, shall we? In the Court of Appeals of Virginia, this was submitted on the 23rd, as you can tell. This is the official brief, okay? Up until this point, on Wednesday and Thursday last week, we covered the amici briefs. Those were submitted as friends of the court, or as Andrea very, very rightfully put it, friends of Amber briefs, because that's more what they sounded like. This one is the official brief that her law firm that is currently representing her has filed in the case. Now, notice right out of the gate, there's a couple of very interesting things that have happened here that I found very, very unusual. It's actually something that didn't strike me until I looked at it again this morning, or this afternoon after getting it this morning. Welcome, Ziggity Zag, as a member to the channel. Don't forget to like this video, comment below, subscribe to the channel if you haven't already. Right out of the gate, look at this. Do you remember the amici briefs that were filed, those of you who were here on Wednesday and Thursday last week? And if you have not seen the amici briefs, absolutely go check them out, because they are a shit show, devoid of legal argument, nothing but pleas to emotion, pure PR move, zero effect on the case. Notice that, remember Brown and Axelrod? I also did a video on them. They're in the playlist about Amber's and Johnny's appeals. Axelrod and Brown never signed off on the amicus briefs. Not really all that surprising at the end of the day. It's not something that you would typically expect, as lead counsel on the appeal are not going to be also tangentially involved in the case. But I just find it kind of interesting that their name never popped up. Same with Ben Rottenborn. You know, his name never appeared anywhere on the amicus briefs. Again, not really all that surprising at the end of the day. But at the same time, it is noteworthy. It's something to just kind of pay attention to, that they are either trying to distance themselves from the amici briefs, or they simply don't want to get involved, and to show that, look, these people are independent of our firms. They have nothing to do with us. And that is a strategic move. Nothing wrong with that. Okay? So I'm not really calling them out in any way, shape, or form, but it's just another fact that I've noticed. Again, as with all briefs previously, Johnny's brief, the amicus briefs, we start with the table of contents after the main page. This is all, if you're wondering why do they all look structurally the same, it's because the Court of Appeals has very specific rules as to how these briefs are supposed to look like. The style, font, margins, content, for the most part, other than the arguments themselves, all have a very basic set structure. Like you're put in a box in the Court of Appeals because the judges don't want to look at 20 different styles on any given day, every single day. They want a same specific style, and that's what they want to look at. Okay. So first, we're going to start with the table of authorities, the statement of the case. They're going to remind the court of their assignments of error. Then they're going to go into the statement of facts. The facts are only going to go on for about 5 pages, 4 or 5 pages, it looks like. Seems about standard. They're going to talk about the 2016 domestic violence proceeding, DEPP'S lawsuit against the Sun, the op-ed, DEPP'S lawsuit against ERRED. So see, right out of the gate, we know that once again, they're going to be bringing in the UK trial into the mix. And I think that just detracts from the brief so much. That detracts from the argument so much. You're in the court in the United States of America. Bringing in any factoid from another court that has different rules from a different jurisdiction is just not smart strategically. But again, I understand as when you're in loser court, because that's where Amber is right now. She's in loser court. She lost the case. We call it loser court, Court of Appeals. It's where parties who lose the case go to fight a second chance, try and get a second shot to maybe show the court that something went awry, something went wrong in the district court level or the circuit court level, and now the Court of Appeals needs to come in and fix it based on the law. I said it before, I will say it again because this is so important. You do not get a chance to retry your case at the Court of Appeals level. Your appeal will get discarded and denied. You only argue issues of law. Assignments of error when it comes to issues of law. If there is a legal argument to be made, for example, a jury instruction that was improperly given, or a jury instruction that should have been given but was not, that is a legal argument. You don't get to argue, well, the jury did not understand this fact and therefore they got it wrong, like the amicus briefs did. Like, that's bonkers. That's not what an appeal is. And sometimes I think these people lose sight of the fact of where they are and who their audience is. The amicus briefs, I think we are all in agreement, are a pure 100% PR move. No question about it. No question about it. But this brief, why it's so crucial and why it's so important is that this brief guaranteed the Court of Appeals judges, the panel that is going to be deciding Amber Heard versus Johnny Depp on appeal. Remember, parties are flipped because she's the one appealing. Amber Heard versus Johnny Depp, they are going to be reading this brief 100%. Not even 99.9, 100%. Why? Because she's a party to the litigation and her lawyers drafted this. So this is 100%. The Court of Appeals judges are going to be reading every word of this for the most part, you know, maybe skipping around. I can't predict what appeals judges do. In the interest of time, sometimes they will, once they get the gist, they will kind of start fast forwarding. I'm sure. Otherwise, you'll just lose your mind reading every word and trying to get into it. Not just with this case, with any case. Because Court of Appeals judges have a lot of work and a lot of cases. I think we've all discussed that this brief is only going to be read probably sometime maybe in the summer or fall of next year. And then the opinion is going to come out probably winter of next year. So they're backlogged, and that's not uncommon at all. Then the relevant pretrial proceedings, and then the trial. Okay, the argument. Let's get into the argument. What is the argument going to be about? Ms. Heard is going to argue the following things. Number one, this is her first argument. The trial court erred by not dismissing DEPP'S claims prior to trial. So right out of the gate, they're going to say, look, the court should have granted summary judgment, basically. The court should have dismissed all claims that had no basis to stand, should have been dismissed, should have never gone to a trial by jury. You made a mistake, Judge Ascarati. Don't forget, every single one of these is almost an outward attack and is going to be an attack on Judge Ascarati's decisions. And that's normal. That's okay. This is how it happens. It's the reality of things. You're telling the Court of Appeals, hey, the judge below in the circuit court got things wrong. Please fix. There's your meme. Trial court, and it's broken down into several sub-arguments that they will argue piece by piece. And this is standard. You want it well-organized, cogent, coherent, because it makes things easier to follow. And when you're reading like the 7th or 8th brief in a case, a judge suddenly wants to go back and say, wait a minute, I remember that argument being made in the opening brief, and it makes it easier for them to be able to go back and take a look at it. The trial court should have dismissed DEPP'S claims on the grounds of forum non convenience. That is Latin for it is an inconvenient forum, doesn't make any sense. Why are we in Virginia? We both live in California. This should have been filed in California. So that's part A of should have been dismissed. DEPP'S claims should have been dismissed. Basically his complaint. DEPP'S defamation claims arose outside of Virginia, and Virginia was a completely inconvenient forum. Anna S. says, why is the brief more than 50 pages plus the 5 extra pages that were granted? Does the table of contents not count? No, the table of contents does not count per the rules. Great question, Anna. Great question. As you will see at the bottom, you see that little I? You see that little I right here? That little I means it does not count towards the pages. The pages start where it starts counting 1, that's page 1. And the Court of Appeals does not include exhibits and basically where your facts begin or where your argument begins, and even the assignments of error. Basically, I think the statement of facts and the assignment of error, possibly the statement of the case. Statement of the case is page 1, yeah. So statement of the case is where the count really begins. So they have 55 pages to make their argument. Great question, by the way. Phenomenal question. I hope that answers it. B, under argument number 1, why else should the trial court have dismissed it? The trial court should have dismissed DEPP'S claims because the challenge statements are non-actionable expressions of opinion. So the opinion argument is going to come back. The trial court should have dismissed, this is C, the trial court should have dismissed DEPP'S claims because the challenge statements are not reasonably capable of conveying a defamatory implication as a matter of law. Again, we're looking for legal arguments. This is not the time to argue passion or emotion. That will be discarded by the judges and thrown into the dumpster. Am I busy this afternoon? Yes, I'm going to be doing this. C. Warren. Am I going to be streaming Taxes versus Ortiz? No, I don't normally stream trials. They come back from lunch at 2:15 Central. That is fantastic, but unfortunately, I will not be doing that. But thank you for shouting that out. I had no idea that case is going on. Thank you. The trial court should have dismissed DEPP'S claims. This is part 4. The trial court should have dismissed DEPP'S claims because the doctrine of issue preclusion prevents, and this is the comity argument, by the way, this is the same argument that was made in the second brief, I believe, their last point of the amici briefs that talked about the First Amendment. The video is on my channel. Feel free to check it out. should have dismissed because of issue preclusion prevents re-litigation of the UK's court ruling that Heard's abuse accusations are substantially true. Now, again, the problem with that is Amber Heard was not sued in the UK. It was the lawsuit against the Sun. So it's not even a re-litigation. It's a litigation of the issue, and the litigant on the other side is the person who made the statements, not the newspaper. It would have been a much different situation if Johnny had sued the Washington Post rather than Amber, and they would still not have like much ground to stand on, again, because the Washington Post is not the Sun and the Sun is not the Washington Post, but they're both newspapers. That argument is a little bit better, but it's still terrible. The trial court erred in denying Heard's motion. This is argument number 2 now, under umbrella argument number 2. The trial court erred in denying Heard's motion to set aside the jury's verdict based on DEPP'S failure to prove actual malice. So after the jury came back, made their decision, awarded damages in the amount of $10.35 million to Johnny Depp over Amber Heard's defamatory statements, they made, if you remember, in June, Elaine Bredehoft argued on behalf of Amber Heard. She argued that this verdict needs to be set aside, and here's why. And the judge said no. A, Depp failed to prove by clear and convincing evidence that Heard was aware of and intended to communicate the alleged defamatory implication. That's another fancy way of saying the jury was wrong. Terrible argument. Depp failed to prove by clear and convincing evidence that Heard either knew the alleged implication that he had abused her was false or subjectively entertained serious doubts about its truth. Again, it's a jury was wrong argument. This is going to be a really bad one. I can't wait to get to this one. I mean, the first one doesn't seem to have a lot of substance either. But look, I always say this because people seem to forget. They're like, well, these arguments are terrible. Why are they making these arguments? That's because they don't have anything better. They literally have nothing to argue. So they're hanging on to dear life to anything and everything they can hang their hat on. And typically, and I haven't seen this in this brief, I don't know if the third one we haven't gotten to in the moment, which we will in a moment. When you make your arguments, you usually want to make your strongest argument first. Why? If it's the most powerful, if it's has the most force, you usually want to make it first, even though it may be a little bit out of order. I know they're kind of going chronologically here, which is not always the best decision. Like, it should have been dismissed before we even got here. Now they're like, well, after the trial, it should have been dismissed because this. The strongest argument should always come first, because that is the one that's going to have the most force, the most panache. You want to, like in a boxing match, you don't start, poking at the guy first. You want to throw a jab in, and then when he's down on the ground, you can poke at him a little bit, right? You don't start out poking, and then all of a sudden, when you're knocked out, try and swing from the floor and try to be like, all right, I hope I'm hitting something because I can't see because my eye is so swollen, That's not how a fight works. So I don't know. I don't understand why they're doing this way. But again, as a defense attorney, I understand. When you have shit, you have to put shit on the table. When you don't have anything good, you put your nothing good on the table because that's all you have. And you try the best you can. That's how the law works. We don't create the facts, unless you're Amber, I suppose. But we don't create the facts. We take the facts for what they are, for how they are on the table, and then we try and craft our arguments. Whatever argument, I remember I had a law school professor tell me this, if you can make an argument with a straight face, then it's an argument worth making, basically. So there you have it. Argument number 3. The trial court erred in failing to grant a new trial for multiple reasons. So they're like, we also asked for a new trial, and the trial court failed to grant us a new trial. The trial court made numerous evidentiary errors. This was point A, which is broken down into subparts, which are also broken down into subparts. The trial court made numerous evidentiary errors that severely prejudiced Heard at trial. What are those evidentiary errors? Number one, the trial court erred by excluding evidence of DEPP'S abuse and Heard's state of mind. That is their first point of error under the evidentiary errors that the trial court should not have allowed. Heard's reports of abuse to medical providers plainly were admissible. These were not admitted by Judge Escarati. If you remember, there was a moment when Elaine Bredehoft tried to backdoor it in and it failed miserably because Amber cannot testify on behalf of the doctor. I know what Elaine was trying to do because I was in the courtroom and I saw, I could see Elaine's, her exhibit because I was that close to the podium. And on her podium, she had a diagram of, I don't know, maybe it was a doctor gave her a sketch or whatever. And she was trying to show something about the nose. And she was trying to get Amber to say it. And there was objection, this is not the proper witness, objection. And she couldn't get it in because it was the wrong witness. It was a good maybe piece of paper for something, but it was the wrong witness. You don't get it in through Amber herself. Nicholas Straw, Labor Law Santa says they are repeating these arguments because it is literally the only ones they got. The former Marine, now judge, did an excellent job. Immediately Damage says, told you guys, this is wonderful comic relief. Thank you, Tofo, for the super sticker. All right. Next. That's number two. Number two, and thank you, Nezuko, for the super sticker as well. The trial court made another error. The trial court wrongly excluded corroborating testimony of Heard's allegations. Number two, the trial court improperly excluded the UK judgment. Again, we're going back to argument number one. Okay. Three, the trial court erred when it precluded Depp from answering a question about the truth of one of the allegedly defamatory statements, possibly on hearsay grounds. That's pretty much going to be 99% of the objections here that happened during the trial. And number four, the trial court erroneously admitted irrelevant and prejudicial evidence. For example, we have two, the trial court committed reversible error. That's a big one. Reversible error is very, very scary to read. When it admitted extrinsic evidence of Heard's pledge to donate money to a charity. Okay. Well, the problem is, as you will see when I talk about it, your character and your propensity to tell the truth is always an issue, is always at issue in a trial. But we'll see. The trial court committed reversible error when it admitted extrinsic evidence of Heard's alleged domestic abuse more than a decade ago. Again, pattern of behavior. But okay, we'll see. We'll see. Remember, pattern of behavior can always come in. Judges will let that in routinely because it shows the state of mind of the individual and their propensity to do or not do certain things. The trial court's evidentiary rulings, number five, encouraged the jury to award damages unrelated to the op-ed. Hold on a second. Wait a minute. Pause everything. That can literally, if you change one word, change the one word to two words, this can literally be used by Johnny in his brief, if you think about it. The trial court's evidentiary rulings encouraged the jury to award damages unrelated to Depp's statement, because it was not Depp's statement. It was Adam Waldman's statement, who's back on Twitter, by the way. Shout out to Adam Waldman. Welcome back, sir. The trial court made evidentiary rulings damages unrelated to the op-ed. Oh, that is rich. That is rich. First, you argue in your brief, in your closing argument and to the jury that the Depp-Waldman statement is what you're going to be deciding. And then they go back and say, oh, by the way, the jury awarded damages completely not related to anything that has been going on here. Like, come on. Come on, that is so rich. That is so rich, my cheeks are hurting. I love how they try to flip the script. But okay, we'll see. We're going to be reading all of these. Oh, buckle up, Buttercup. This is going to be a shit show. The trial court erred by not dismissing the claim based on the headline for the web version of the op-ed because the evidence established that Heard did not publish it, but she admitted to it. Okay. When I published the op-ed, she said it on the stand. The trial court improperly instructed the jury on actual malice. They took a page on that. The jury verdicts are inherently and irreconcilably inconsistent. That is actually potentially their strongest argument. I don't know why they're making it next to last and they're spending about a half a page on it, but okay. The jury's damages award is excessive. What? Okay. I mean, are they talking about the 5 million because that has been reduced? We'll see. We'll see. Conclusion. And it's on page 55. So it's 55 pages, like promised. So far, I'll be honest, I am not impressed. I am not impressed. And again, see that little Roman numeral 3 at the bottom? It does not count towards the page count. Remember that. Table of authorities. Now, you'll notice, and I'm going to tell you this right now. If we are to compare, I haven't even seen this yet. I have not even seen this, but I can tell you, if we were to compare how many cases are cited in this brief versus what is cited in the amicus briefs, I can tell you right now, there are going to be way more cases and way more case law, at least there should be, in the lead plaintiff's opening brief. Why? Because you want to argue law. You don't want to argue policy. Policy is weak. Policy is trash. You want to argue case law. We have 1 page of case law. We have 2 page of case law, 3 page of case law, 4 page, 5, 6. See, that's a brief. That's a brief. Then we have some statutes. We have some other authorities to other rules. Again, see, there's an X on the bottom. This is page 10 of the minutia, if you will, just introducing the court to this stuff. None of these pages count. This is technically like a 66 to 68 or whatever page brief. It is not. The first 11, 12 pages don't count. The appendices at the end don't count. The signature pages don't count. The only thing that counts is what starts with this right here. This is the meat. Now we get to the meat. Statement of the case. Statement of the case. In 2016, appellant Amber Heard obtained a domestic violence TRO against her then husband, appellee John C. Depp II. 2 years later, Heard authored an opinion piece. Did they just admit to that as well? Heard authored. She authored an opinion piece. They're about to have inconsistencies in their own brief, aren't they? I mean, it's already starting. Wasn't one of their arguments that they're about to make is that she had nothing to do with it? What happens when you lie? You accidentally end up contradicting yourself. But we'll see. We'll see. Two years later, Heard authored an opinion piece ultimately published in the Washington Post in which she discussed the public backlash she had experienced after that legal proceeding and advocated for policy changes to support women who report gender-based violence. Heard took great care not to mention Depp or to repeat her prior allegations of abuse by him, which, by the way, if you all remember, there's a bunch of exchanges between her and her lawyers when she gets an email from somebody in the bowels of the Washington Post. They're like, we want to write this piece. And she's like, well, let me run it by my lawyers, make sure I don't get into legal trouble over this. That was very important for her to do because she knew she might be stepping in some doo-doo. And she was right. but she still did it. But Depp sued Heard for defamation, claiming she had revived her 2016 allegations merely by describing the reaction to them. Instead of suing Heard in California, where both parties lived and where Depp claimed to have suffered reputational harm, Depp sued in Virginia, a wholly inconvenient forum with no connections to Depp or any meaningful connection to his claims. The trial court erroneously refused to dismiss this action on the grounds of forum non-convenience. There were some pretrial motions made to that effect, I am certain, based on its mistaken conclusion that Depp's claims arose in Virginia because the Washington Post's servers are located here in Virginia. The trial court also erred in overruling Heard's demurrer, in which she argued that the challenge statements are non-actionable expressions of opinion and are not reasonably capable of conveying the alleged defamatory implication. That holding, if allowed to stand, undoubtedly will have a chilling effect. There it is, our favorite language. Chills running down our spines just thinking about it. Chilling effect on other women who wish to speak up about abuse involving powerful men. This case also should never have gone to trial because another court had already concluded that Depp abused Heard on multiple occasions. So you will notice a direct parallel. The arguments that we just went over one by one, if you all remember, there are I think there were five main arguments that they have made. Now they're kind of outlining in story form. They're preparing the judges. This is what you're going to see. This is what we're going to argue. This is what went wrong with this case. And then they'll give their justifications under the argument portion. After Depp filed this case, the United Kingdom High Court of Justice ruled in a separate defamation action brought by Depp. And by the way, again, a Court of Appeals judge would look at it. The Court of Appeals judge would look at this and go, look, I get it. You didn't like that you won there and you lost here, but you can't just say, I don't like it. You have to show me why I should agree with you as a Court of Appeals judge. You can't just say, na, and expect us to do something about it. You have to give me the tools or give me where I can find the tools that allow me to look at the UK judgment and go, yeah, that should stand. You can't just say it. You can say it and you can have an article written by fucking CNN, Fox News, all these media outlets that you can conceive of that are taking Amber's side. They can do that all day long, but they don't have the power of the judicial system. They are simply disseminators of information or misinformation, as some of you may argue. So the key is to give the judges the rightful tools which will allow them to make a decision based on law, case law, precedent, okay? Because this decision, once decided, will be in the law books forever. And other courts across the country, all across the country, not just Virginia, are going to be relying on this piece of literature that the judges are going to be drafting. So the judges in this case are very, very lucky in the sense of their piece is definitely going to be cited, and it's going to be cited a lot. So whatever they decide is going to have a monumental effect on everybody that has defamation cases moving forward. And to include what are we bringing back, like common law? Are we bringing back United Kingdom law into the United States? I mean, I thought that ended in 1776. Amber's team, you're about 250 years behind. Nicholas Stero, Labor Law Santa says, when you tell a lie, make it big and repeat it until it becomes truth. Julius Caesar and Hermann Goering. Very true. Okay. After Depp filed it, the United Kingdom High Court of Justice ruled in a separate defamation in the separate defamation action brought by Depp that Heard's abuse allegations were true. Fantastic. We don't care. This is the United States. This is a different case. This is a different defendant, with different defenses. The trial court should have given preclusive effect to the 129-page decision, which followed a 3-week trial at which Depp, Heard, and 24 other witnesses testified. And by the way, just for the record, before I had stated that they never got a chance to cross-examine Amber, I was wrong about that. I believe Black Belt Barrister is the one who said that initially, and he admitted that it was a mistake, and I kind of went with it because I didn't know. But there are still other rules in the United Kingdom that they follow that we don't follow, and vice versa, that are not permissible here, permissible there, and vice versa, which still have a completely different effect. And again, it's a different defendant. Most importantly, he did not sue the Sun in the United Kingdom. Johnny Depp did not sue the Sun newspaper. Johnny Depp did not sue the Sun newspaper in the United States. He sued the Sun newspaper in the United Kingdom. He sued Amber Heard in the United States. I can't believe I have to repeat this so many times that, I mean, it just doesn't get through the skull of her attorneys. I'm flabbergasted. Once this case did go to trial, Depp failed as a matter of law to meet his burden to prove actual malice by clear and convincing evidence in 2 ways. Fancy way of saying the jury was wrong. 2 ways. First, he did not demonstrate that Heard was aware of and intended to communicate the alleged defamatory implication that he had abused her. And second, he did not establish that Heard knew the alleged implication was false or subjectively entertained serious doubts about its truth. Both of things which the jury decided in Depp's favor. Case closed. But now they're trying to argue, no, case not closed, here's why. What JD couldn't do in the UK trial was give direct. Okay, well, there you go. Possibly. Thank you, Ian Kinzel, for that. The trial court erred in declining to set aside the jury verdict and enter judgment in Heard's favor. As the 6-week trial unfolded, the trial court made numerous evidentiary errors that severely prejudiced Heard, both by excluding highly probative evidence and by admitting irrelevant and prejudicial evidence. The trial court further erred by not dismissing one of the challenged statements because the undisputed evidence showed that Heard simply did not publish it. She already admitted to that, man. Come on. The trial court then refused Heard's proposed jury instruction on the communicative intent prong of actual malice. Consequently, the jury instructions were missing a key requirement for establishing a defamation by implication claim. In addition, the resulting jury verdict against Heard on all of Depp's claims cannot be reconciled with the jury verdict against Depp on Heard's counterclaim. To find in favor of Depp, the jury must have concluded that Depp did not abuse Heard and that Heard knowingly lied in accusing him of abuse. But that's true. That's what the jury concluded. Where's the problem? But to find in favor of Heard, the jury must have concluded that Heard told the truth about being a victim of domestic abuse by Johnny Depp. Accordingly, the verdict against Heard cannot stand. So they're saying it's conflicted. The jury could not have awarded both of them damages. You can't have the yin and the yang. You got to pick one. It's not the best argument, but I think that's actually the best that they've got, as I've already alluded to. The inconsistency of the verdict is probably their strongest piece because the jury was just too confused. But it's still, I don't know if it's enough. It may be harmless error, and the jury concluded what it concluded. But we'll see. We'll see. That, I think, by far, that is their strongest argument. It still doesn't. It's not strong by itself, but compared to everything that they have, I think that is their strongest argument. Finally, even if this court were to disagree with all of the foregoing, the jury's award to Depp of $10 million in compensatory damages and $5 million in punitive damages, which statutorily was reduced to $350,000, clearly is excessive given the narrow time frame for which Depp could recover. The narrow time frame. What narrow time frame? He's an A-list actor. Are you kidding me? He asked for $50 million because he lost at least 2 roles that we know of. The Fantastic Beasts, which was critically acclaimed, J.K. Rowling, third movie of the subsequent saga of like the Harry Potter, pre-Harry Potter series, and then Pirates of the Caribbean 6, which would have netted him millions. I mean, those 2 movies alone are probably half of what he asked for, plus all the other side projects that I don't remember off the top of my head right now. Can Johnny Depp, I imagine, JD, says Bev's Fry Bread Wisdom, sue AH for her keeping saying she was abused after the trial? Yes, but no, nobody cares at this point. The truth is out there. The redefaming. Sure, you can sue, but it's why would you waste more time? You already won. Winners. What do they say? Beggars can be choosers. Winners can be choosers. Winners can choose what to pursue and what not to pursue. So, okay. Now the assignments of error. I imagine this is going to be very directly linked to the assignments of error that we already went over in the trial. I wish you all could see. Hold on, maybe I can show you. Be very, very quiet. Look at this. Can you see her? She's sleeping. She looks so adorable when she sleeps. I legitimately just can't get over how comfortable and cute she looks, especially when I'm live streaming. She just chills. She doesn't care. I absolutely love her. Okay. Let me get this back. All right. So assignments of error. The trial court erred in declining to dismiss the action on the grounds of forum nonconvenience. And now, so up until now, if you noticed, there was no real citations to the record. There was no real indication of where to find these things in the record. Why? Because, well, we haven't gotten there yet. Now, everything that is cited by the writer, the author, the attorneys, must have some reference to the record in the trial court. If not, it will be ignored. Why? Because all errors, all facts, all arguments must have been preserved on the lower level. You didn't preserve it, it didn't happen. We're not going to look at it. Preserved, show us where it is. It's here, okay, we will look at that. The trial court erred in denying, this is number 2 assignment of error, in denying the supplemental plea in bar and in ruling that the November 2nd, 2020 judgment of the UK High Court of Justice, Queen's Bench Division such and such, does not foreclose DEPP'S claims. The trial court erred, number 3, in denying the demurrer and plea in bar and in ruling as a matter of law that the 3 allegedly defamatory statements in the challenged op-ed are A, actionable as statements of fact rather than non-actionable expressions of opinion, and B, actionable as defamation by implication. 4, the trial court erred in excluding from evidence at trial the November 2nd, 2020 judgment of the United Kingdom High Court of Justice, Queen's Bench Division, such and such. 5, the trial court erred in excluding from evidence at trial medical records reflecting Heard's contemporaneous communications with medical providers such as Dr. Laura Anderson, Dr. David Kipper, Debbie Lloyd. If this is not familiar to you, you will recognize this. If it is familiar to you, you know where you've seen this. It's the assignment of error filing that they made a few weeks ago. This is literally it. Aaron Falati, Dr. Amy Banks, Dr. Connell Cowan, and Dr. Bonnie Jacobs, and B, Heard's contemporaneous communications with several third parties, including Depp's employees and Heard's employees, friends, and family, about interactions with Depp, including reports of drug use, aggressive and abusive conduct, physical and sexual abuse, and her fear for her safety. 6, the trial court erred in admitting irrelevant and unduly prejudicial evidence at trial related to Heard's pledge to donate money to charity and evidence related to Heard's alleged abuse of third parties. Trial court erred in excluding 7, evidence at trial of Depp's reputation as it existed prior to publication of the challenged op-ed and after the op-ed was published. This is all the tabloid stuff. 8, the trial court erred in sustaining an objection during the cross-examination of Depp to a question about the truth of one of the alleged defamatory statements on the grounds that it was called for a legal conclusion. 9, the trial court erred in allowing Depp to argue or suggest at trial that the jury could award damages based on statements or conduct occurring prior to the publication of the challenged op-ed. 10, the trial court erred in allowing Depp to argue or suggest at trial and the jury to consider whether the allegedly defamatory statements in the challenged op-ed were republications of statements Heard made in 2016 in connection with a domestic violence TRO she obtained against Depp. 11, the trial court, which rejected proposed jury instruction CC, improperly instructed the jury on actual malice. 12, the trial court erred in denying the motions to strike and to set aside the jury's verdict with regard to Depp's failure to prove publication by Heard of the statement I spoke against sexual violence and faced our culture's wrath. That has to change. 13, the trial court erred in denying the motion to set aside the jury's verdict with regard to Depp's failure to prove that the allegedly defamatory statements in the challenged op-ed each conveyed a defamatory meaning about him by implication, and that any such implication was both designed and intended by Heard. 14, the trial court erred in denying the motion to strike and to set aside the jury's verdict with regard to Depp's failure to prove actual malice by clear and convincing evidence. 15, the trial court erred in denying the motion to set aside the jury's verdict and ruling that the jury's verdicts in favor of Depp on his claims against Heard and in favor of Heard on her claims against Depp were not inherently and irreconcilably inconsistent. And finally, number 16, the trial court erred in denying the motion to set aside the jury's verdict and upholding the amount of the jury's damages award in light of A, Depp's failure to prove pecuniary damages, and B, the excessiveness of the compensatory and punitive damages awards. Those are the arguments. Assignments of error. Statement of facts. Part 1, the 2016 domestic violence proceeding. Depp and Heard are actors who first met in 2009. They married in 2015, but their marriage was short-lived. In May 2016, Heard filed for a divorce and for a domestic violence TRO against Depp in Los Angeles Superior Court. In support, she submitted a declaration describing Depp's temper, paranoia, and substance abuse issues. Heard also alleged that Depp grabbed and pushed her, threw a cell phone in her face, pulled her hair, smashed wine bottles in her vicinity, destroyed her personal property, and threatened her. After a hearing, the court granted the TRO. According to Depp, he lost nothing less than everything, quote unquote, from, quote, the second, end quote, Heard applied for the restraining order in 2016. From the second that Heard applied for the restraining order in 2016. The accusations were widely reported in the media, and Depp quickly became associated with them. Once the divorce became final in January 2017, the parties issued a joint statement confirming, quote, neither party has made false accusations for financial gain, end quote. Number 2, Depp's lawsuit against The Sun. A British newspaper, The Sun, published an article on April 27, 2018, that referred to Depp as a wife beater. It will be referred to as the Sun article. Depp sued The Sun for libel. Libel is written defamation in the United Kingdom. He alleged that the Sun article had caused serious harm to his personal and professional reputation. The Sun asserted the defense of truth, contending that Depp had, in fact, beaten Heard. The parties to the UK proceeding engaged in full discovery. culminating in a 3-week trial with 26 witnesses in July 2020. Although not a party, the key language, by the way, trying to slide it in like, oh, by the way, although not a party, but she was a witness. Although not a party, Heard was an active participant, providing evidence and 7 witness statements and testifying for 4 days at trial. Depp had access to 16 months of discovery in this litigation, which he used in the UK proceeding. On November 2nd, 2020, the UK court issued a 129-page judgment dismissing Depp's claims against the Sun on the basis that Heard's prior allegations of abuse were true. That's the UK judgment, is what it's going to be referred to as hereforth. Specifically, the UK court found sufficient evidence to establish that at least 12 incidents of abuse had occurred. By March 31st, 2021, Depp had exhausted his appeals, leaving the UK judgment in place. Now the op-ed. In late 2018, thank you very much, Viking, for the super sticker. Thank you. In late 2018, while the UK proceeding was pending, the American Civil Liberties Union invited Heard to serve as an ambassador on women's rights and proposed that she author an op-ed advocating for policy changes to protect victims of gender-based violence. So she is the author. Now we have it confirmed. We already knew that, but now it's in the brief and it's cited to the record. The Washington Post published the op-ed on its website on December 18th, 2018, and in print on December 19th. Heard then posted a link to the online version from her personal Twitter account. They had to be very careful with their language here, because if they had used any sort of language like republished, then they would have been admitting one of the claims in Depp's defamation suit. So they had to be extremely careful about the choice of words right here. She posted a link. Depp's lawsuit against Heard, Part 4. On March 1st, 2019, Depp filed this action alleging, although the op-ed never identified him by name, it revived the domestic abuse allegations Heard had made in seeking the 2016 restraining order. Depp based his claims on 3 statements. 1, the headline for the online version, quote, Amber Heard, I spoke up against sexual violence and faced our culture's wrath. That has to change. 2, then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women to speak out. And 3, I had the rare vantage point of seeking in real time how institutions protect men accused of abuse. And we have a couple of citations here in the footnotes. If you notice, when I did the amicus briefs, I kind of skipped the footnotes for the most part, just because I wanted to get into the get through them. These ones we're going to be reading everything, because the footnotes, although relevant, I wanted to cover the crux of the argument. Here we're going to be covering absolutely every nook and cranny, because this is the most important piece that Amber's team has written in furtherance of her appeal, trying to win, obviously. The print version of the op-ed had a different headline, a transformative moment for women, which Depp did not challenge. I don't see how that's relevant, but okay. He chose to challenge what he challenged. That's his choice as the plaintiff filing the lawsuit. Depp originally challenged a 4th statement, which the trial court held was not actionable, and that has been removed by the court. Okay. Number 5, relevant pretrial proceedings. Heard initially moved to dismiss on grounds, thank you very much for the kitty treats fund, says Mad Scientist Cinema. Thank you. For the kitty. Did you hear that? Oh, she's asleep. Shh. Let's not wake her. Heard initially moved to dismiss on the grounds of forum nonconvenience, which the trial court denied. Heard then filed a demurrer seeking dismissal of all claims, arguing that the challenged statements were not actionable as defamation by implication, and that all but one were expressions of non-actionable opinion. The trial court overruled the demurrer in relevant part. On August 10th, 2020, Heard filed counterclaims against Depp, including defamation claims arising from 3 statements made by Depp's attorney. Oh my God. Tell me this is not, I mean, this is it. This is part of the record. How did they, I don't understand how these people sleep at night. Like, that's an admission that it's not Depp Waldman's statement. It is a Waldman statement. Clearly. Is this a joke? Is this a fucking joke? Like, did they just hire a paralegal and say, look, you have a job to do here, just write this. Did you watch the trial? No, it doesn't matter. Just fucking write it. This is insanity. Including defamation arising from 3 statements made by Depp's lawyer. The statements that Depp's lawyer made. Oh my God. So now we have 2. She wrote the op-ed and Depp's lawyer wrote the statements that she sued under. Wow. A monkey wrote this, you guys. A fucking monkey wrote this. I can't believe it. I cannot believe this is actually real. This is reality. This is the world we live in. I can't even hold it in. Like, it's bursting out of me. This is crazy. So the whole time when we were saying Johnny Depp made these statements, we were kidding. Sorry about that. It was actually his lawyer. We knew the whole time. We just didn't want to tell you. See, when you lie, it's easy to lie once. It's a lot harder to lie twice. And when you try to lie for the 3rd, 4th, 12th, 15th, 27th time, and your lies are so stacked up on top of each other, you start slipping up. And when you start slipping up, that's where the magic happens, because the outside world begins to take notice. So, are you sure they're appellate attorneys, says Julie Gibson? This is crap. I mean, hey, you're looking at me. All right, let's keep going. See if we can find some more golden nuggets. So far we have 2. We're only on page 8. We already have 2 golden nuggets. Whew. Can I trade them in for value? Jesus. On April 13th, 2021, while the parties were engaged in discovery, Heard filed a supplemental plea in bar after the UK judgment had become final, arguing that Depp should be precluded from relitigating the UK court's finding that her domestic abuse accusations were true. I'm not going back to talk about why. I already said it like 5 times. You all already know by now. The trial court overruled the supplemental plea in bar. Yes, we know. Number 6, the trial. On April 11th, 2022, the case proceeded to a 6-week trial. Notwithstanding that Depp focused on attacking Heard's credibility and portraying her as a liar, the court precluded Heard from introducing documents and other evidence corroborating her accusations. Now, this is the PR argument, if you all remember. This is straight up the PR argument. This is the we have mountains of evidence, and the judge just wouldn't let it in. Ben Chu and Vasquez reading this and seeing another Kate Moss moment, probably. Most definitely, because in their response, they're going to be addressing all those things. And I hope they watched this video too. I mean, I'm sure they didn't, but I'm just saying because I am literally finding things in real time, and it's fabulous that we what a day what a day and age to live in, right? We have some rando lawyer from Kentucky that is so deeply involved in this case, and he never intended for that to happen. And now I can read a brief to, what do we have? We have 2,200 people literally live sitting with me right now on the other side of the screen, and there's going to be tons and tons and tons more watching this. It's just bonkers. It's just bonkers. What a day to be alive. What a time to be alive. It's absolutely fascinating and amazing, and I love every minute of it. So okay, so that's the PR argument. We had mountains of evidence. It's just naughty. Judge Ascarati didn't let us in. Did that just rhyme? Naughty, Judge Ascarati. Oh boy, please, somebody put a bullet in my head, because that should not have come out like that. That was not my intent. Jesus Christ, Larry, get your shit together. All right. The court precluded Heard from introducing documents and other evidence corroborating her accusations, and allowed Depp to admit irrelevant and unduly prejudicial evidence that he further used to attack Heard's character. At the close of Depp's case, Heard filed a motion to strike the evidence on multiple grounds, which the trial court denied. On June 1st, the jury returned a verdict in favor of Depp on all his claims and in favor of Heard on one of the counterclaims. The jury awarded Depp $10 million compensatory damages and $5 million in punitive damages, which the trial court reduced to the statutory cap of $350,000 pursuant to code such and such, and awarded Heard $2 million in compensatory damages. On July 1st, Heard filed post-trial motions on a number of grounds, which the trial court denied without argument, which is false. I remember they did make the argument, but the court just did not entertain the argument, which is fine, or opinion. Again, no opinion was made. It was probably ruled from the bench. All right. Let's get to the fun stuff. The argument itself, you guys, this is it. This is the kit and caboodle. Woo. Do you feel the heat rising? I sure do. All right. The argument. Argument number 1. The trial court erred by not dismissing Depp's claims prior to trial. For each of 4 independent reasons, the trial court should have dismissed the action prior to trial. Reason number 1 as to why it should have been dismissed, according to Ms. Heard. The trial court should have dismissed Depp's claims on the ground of forum non-convenience. This case should never have been tried in Virginia. The court overwhelmingly demonstrated that Virginia had no meaningful connection to Depp's claims and that California was the only appropriate venue. By filing in Virginia, this is footnote number 3, Depp presumably sought to avoid California's strong anti-SLAPP law, which has given rise to an early motion practice in California defamation suits that provide a potentially potent weapon for defendants. The trial court therefore erred in denying Heard's motion to dismiss the action for forum non-convenience, and Depp's claims should now be dismissed without prejudice for this reason. Virginia's forum non-convenience statutes permits a trial court, for good cause shown, to dismiss an action brought by a person who is not a resident of the Commonwealth without prejudice, if the cause of action arose outside the Commonwealth, and if the court determines that a more convenient forum which has jurisdiction over all the parties is available in a jurisdiction other than the Commonwealth. So being a resident is one qualification, and having jurisdiction over multiple parties in a different jurisdiction, if that's more viable, you should go there. The trial court's decision is reviewed for abuse of discretion, which is a very, very low standard, meaning if Judge Ascarati abused her discretion for failing to dismiss the action for failure to file in the proper forum, then the Court of Appeals will agree and reverse. A court abuses its discretion when it makes an error of law. Here, the trial court made an error of law in concluding that DEPP'S defamation claims arose in Virginia rather than outside of the Commonwealth. Had the trial court correctly applied the law in this regard, it then would have been required to consider a more convenient forum with jurisdiction over both parties was available. The evidence before the trial court clearly demonstrated that California was such a jurisdiction. But because of its erroneous legal conclusion, the trial court never even considered the substantial inconvenience and prejudice that litigating in Virginia would impose on Ms. Heard. Let me just pause right there for a second. Let's talk about it. Thank you, C. Adams. Let's talk about it. So what do we have so far? Retired Nana, she did not pay the bond and it was not waived, so Johnny can pursue his $10.35 million against Amber. The forum non-convenience argument, which I don't understand why they're leading with it, if they think that this is their strongest argument, usually those arguments truly are the weakest, because the trial court is in the best position to determine such, unless it was a clear abuse of discretion, which is probably what they're about to argue here in just a few moments. But trying to predict where they're headed and why it's wrong and is going to fail is, they didn't just pick Virginia because, look, it's got more favorable laws and more favorable rules, which, by the way, goes into the calculus of choosing the forum of where to file. And sometimes you will have multiple forums available to you as a litigant, as a plaintiff. You know, if your neighbor throws a rock at your house and you live in Montana, you're not going to go down to Florida and file in Florida because it is a better forum for purposes of the law. The law is more favorable for rock throwing, let's say, in Florida than it is in Montana. That's nonsensical. That's not going to happen. But if you are arguing that you came to Virginia and your sole purpose was to just find a more suitable forum for you, it's a very weak argument, because lawyers and litigants do this all the time. If you have multiple forums available to you within the United States, then you are going to choose the forum that is more convenient for you and the one that is most favorable, has the best established law for you. Thank you, Leah Dahlquist, for the super sticker. I mean, that's just the bottom line. That's just facts of life. And I know her lawyers know that, but they're trying to backdoor it by saying, look, that's the only reason, but it's not the only reason. The main reason why they filed in Virginia is because, this is the argument that defeats the forum non-convenience arguments that Johnny will make and will file 30 days from now, or 30 days from November 23rd. So December 23rd is when we should have our hands on this brief, or thereafter, right around that time, is the basic precept that the Washington Post is headquartered in Virginia. The article that he was suing Amber over was born, originated, published in the bowels of the Washington Post Center, which has its nerve system, its brain, its spine in Virginia. Let's see what they've got. Number one, under this argument, Depp's defamation claims arose outside of Virginia. So they're about to say that the actions, all of the actions that led to Amber writing this piece did not occur in Virginia. And that is a true statement, but that is a terrible argument for the reasons I just stated. The trial court ruled that Depp's defamation claims arose in Virginia solely because the Washington Post uploaded the op-ed to the internet via computer servers located in Springfield, Virginia. That ruling is inconsistent with Virginia law as applied to internet publications, which dictates that Depp's claims arose in California. Virginia adheres to the rule of lex loci delicti, or place of the wrong, to determine where a tort cause of action arises. For defamation claims, Virginia courts have defined the place of the wrong as the state where the content at issue was published. Wait a minute. Unless I'm missing something, isn't that an admission that the content was published in Virginia? What am I missing? Am I missing something, chat? Help me out here. Because I literally think that citing that case, I think, does not help them. The place of the wrong, fair enough. So they're saying California is the place of the wrong, according to Gilmore. But for defamation claims, let me read it again. Virginia courts have defined the place of the wrong as the state where the content at issue was published. And that's Virginia, essentially. Because the internet does not have a home state. I am very confused. Yes, the Washington Post is headquartered in Virginia, exactly. So the content was published in Virginia. Did you just shoot yourself in the foot at the beginning of your argument? Is this golden nugget number 3? This is golden nugget number 3. Neither the Virginia Supreme Court nor this court, however, has addressed how that rule applies to defamation claims based on internet publications, which reach an audience in multiple states simultaneously. Okay, so there you go. Now they're saying if it was a newspaper, then you can come after us. But because it was published to the internet, nah. Like, are you kidding me? Is this your nah argument? You do realize that nah arguments don't work, right? Oh, but okay. Let's see what else they've got. The trial court incorrectly concluded that publication for purposes of online multi-jurisdictional cases occurs when the defamatory statement is uploaded to the internet. To the contrary, under Virginia law, a statement is not considered to be published until it is seen or heard by a third party. Uploading content to the internet is not enough to constitute the completed tort of defamation. Instead, a third party must also receive and understand the content. So what they're saying is the forum is all 50 states? Because that's the answer. That's the counter to your counter. If you're going to say, look, Virginia was improper, it should have been California, the counter to that, well, if not California or Virginia, we literally could have gone to the other 48 states. This is ridiculous. Not a very good argument at all. Does not pass muster. It just does not. It doesn't have a force behind it. It doesn't have the force of law behind it. For their purposes. I mean, maybe in a different case, but not in this case. I just don't see it. Because the op-ed reached readers everywhere at once, the trial court had no, they just admitted it. They just fucking admitted it. I can't, you guys. I was expecting at least something. Maybe it's coming. I don't know. But like, you can't, out of the gate, you argue your strongest points, the points that like the judges go, okay, I should believe you and reason with you because you know what? You're making some interesting points. Out of the gate, you're coming out with garbage. You're not going to earn the trust of your reader. Forget this lawyer from Kentucky. The Court of Appeals judges are going to be reading this. This is your appeal. This is your time to speak. This is your time to try and argue why the jury was wrong. How are you doing this way? I feel my hairline receding as I'm reading this. How do you do this? Oh my God. Oh man. Nicholas Starro says, just because I read it in Sweden, the article is still on a server in Virginia. The origin of the publication doesn't change. Exactly. Common sense, bro. Common sense. You know what? Zinnia hasn't moved, actually. It's funny. She knows when I go berserk. Her ears perked up. I will tell you that her ears definitely perked up, but she knows it's not directed at her. So Zinnia is a very, very intelligent cat, by the way. Let me tell you. I don't think she's in any way, shape, or form different from other cats. I know a lot of cats are very, very intelligent, and she's no different. So, okay, all right, breathe, Larry. I'm going to read it again in case for those of you who missed it the first time. I'm sorry, my brain just had a conniption. But remember, the argument that they're making is they're saying, look, Virginia is the improper place to file this. You should have filed somewhere else. And the somewhere else is, everywhere. They literally just admitted it in the next sentence that I just read. Yes, you heard me correctly. Virginia is the wrong place to file. You should have filed it anywhere else except Virginia. Literally anywhere. William Plummer says, was the article not also published in the print version of the Washington Post? And that is the next question. That is the other counter that in print it was. But I don't know if that was raised in the trial court and if it really matters, because they would have raised it in the trial court, I imagine, unless the defense completely missed this argument. Guys, I'm literally dying. Slow death. It's amazing. It's incredible. I wouldn't trade this Monday for the world. Such a jam-packed week we've had, and it just continues into the next week. Because the op-ed, I'm reading this sentence again, just so you realize how bonkers it is. Because the op-ed reached readers everywhere at once, the trial court had no basis to find it was published in Virginia rather than in California or elsewhere. I'm face palming so hard inside right now. Numerous courts interpreting Virginia law have concluded that the place of the wrong for internet defamation claims is where the plaintiff incurs the greatest reputational injury, which typically is their home state. Fine, but you can choose. Choice of venue is always an option. Here, that state was California, Depp's home, and the trial court abused its discretion in holding that his claims arose in Virginia. Indeed, this is footnote 4, to the extent Depp incurred any reputational injury, that harm occurred in California, not in Virginia. They're leading with not a very strong argument at all, and I don't understand it. Part 2, as to why it's an inconvenient forum. Virginia was a completely inconvenient forum. That's it? That's your heading? Okay, I'm gonna let it slide. Let's see what we've got. Because the trial court erroneously concluded that Depp's claims arose in Virginia and heard, therefore, let me read that statement again. Because the trial court erroneously concluded that Depp's claims arose in Virginia and heard, therefore, had not met the prerequisite to dismiss the case based on forum nonconvenience, it did not consider whether there was good cause to dismiss the action. Good cause includes, but is not limited to, the avoidance of substantial inconvenience to the parties or the witnesses. So this basically means, look, all the parties, there's nobody living in Virginia. We're all somewhere else. Virginia is a terrible place because it's really, really, really hard. We have to rent hotels and we have to rent cars and we have to get all of our handlers here and da da da. This would be like a better argument for Johnny. Like if Johnny were to make the argument, like, look, I have this entire armada that travels with me, and it's very difficult for me to bring this to Virginia. But he's not the one making the argument. It's Amber. So it's actually, it would have been a much better argument if the roles were reversed and Johnny was like, look, you guys, I have an entire army that travels with me because I am at the top of the food chain when it comes to celebrities. Okay? I can't just like fly by myself commercial. Like I will get literally attacked, not physically, but like verbally. Eyes are going to be going like, is that fucking Johnny Depp sitting in seat 24F on my commercial flight from Dallas to Virginia on American Airlines? Is this a joke? Like, you know, it would never happen. It would never happen. So, okay, all right. But Amber's the one making this argument. Okay. Had the court analyzed good cause, quote unquote, it necessarily would have concluded that Virginia was a completely inconvenient forum for this case. None of the conduct relevant to Depp's defamation claims occurred in Virginia. Depp is a resident of California. The incidents that led to Heard obtaining the TRO took place in California, not Virginia. Heard wrote the op-ed in California. There it is, the admission again. And then sent it to the ACLU in New York. The ACLU provided the so now they're admitting that multiple jurisdictions are involved here. So Virginia is absolutely positively an option. They literally admitted it again. The ACLU provided the op-ed to the Washington Post, which published it online. Heard had no contact with any Washington Post employee. I believe that has already been proven to be false, if I'm not mistaken, as we talked about it already. I believe she did talk to somebody in the bowels of the Washington Post when they reached out and asked, like, hey, do you want to help me write this piece? I'm writing a piece about, abuse and women and all of that. Would you like to partake? And she was like, sure, yeah, absolutely. I'd be happy to. I'd love to, blah, blah, blah. So she didn't just like magically spawn a writing out of nowhere. That's not how pieces are written. That's not how it goes down. That's insanity. Don't forget to like this video, by the way, comment below, subscribe to the channel if you haven't already. Just throw that out there real quick. That's insane. That's crazy. Heard had no contact with any Washington Post employee. That does not pass the smell test at all. To the best of her knowledge, Heard had never set foot in Virginia prior to the lawsuit. To the best of her knowledge, so she doesn't even. That's a very weasel phrase right there. To the best of her knowledge, she doesn't remember if she traveled to Virginia prior to the lawsuit. I don't know. I don't like any of these statements. They're too wishy-washy, and I think they've already been contradicted. In short, the Washington Post's computer server's presence in Springfield is the only, which matters, but okay. The only connection, because that's all you need. You need one connection. If this was a completely random, like, eeny, meeny, miny, mo, catch a feller by the toe. If oh, Virginia. All right, let's go to Virginia, you guys. Pack your bags, Which means Depp's choice of forum is entitled to little weight. In contrast, both parties and most of the fact witnesses were located in California, none of them located in Virginia. Okay, we got that. Because of this error, Heard suffered substantial prejudice in two ways. First, and most significantly, Heard was unable to subpoena any witnesses for the 6-week trial and was forced to rely almost exclusively on deposition designations to defend herself. Now, that is a lie. That is an absolute lie. I think we learned throughout the trial that most of these people she no longer talks to or associates with. and they don't want to come in and support her because they have severed ties with her or she's severed ties with them. So, yeah, we kind of learned that throughout the trial. Unbelievable. And she can subpoena, like, are you kidding me? That's the worst argument in the world. It really is. Forum non-convenience considerations include the availability of compulsory process for attendance for unwilling witnesses. There it is. She had trouble procuring the people who didn't want to come. They're admitting it. They're fucking admitting it in the brief. What? Golden nugget number 5? I'm about to start losing count of our golden nuggets. Oh. Rely almost exclusively on deposition designations to defend herself because most of her witnesses were fucking unwilling to come in and testify on her behalf. What? And Johnny had 50 witnesses from out of town. If that's a fact, there you go. So forum quite convenience. Okay. Another case describing the presentation of deposition testimony at trial as a less desirable procedure, which deprives the trial judge and jury of the ability to evaluate the witnesses in person. Which is true, absolutely true. But if that's all you have for your defense, you gotta play it. I mean, you don't have a choice. You don't have a witness. If they're not willing to sit in that box and testify on your behalf, that's a you problem. That's not Johnny's problem. That's an Amber problem. The lack of compulsory process. So because we couldn't grab these people by the throat and go, you're gonna come in and testify, we were prejudiced, so please mulligan. We got to try this again in California. This is your argument? This is your argument. Sorry, I lost my place. I pushed the button and it went somewhere. Where the heck am I? Okay, there we go. 1 and 2. All right, sorry about this. Okay. So we couldn't grab him by the throat argument. The lack of compulsory process meant, first, that the only live fact witness Heard was able to call in her defense was her own sister. I mean, tell me, just by itself, like taking a step back, just by itself, that right there, isn't that like the saddest thing? That the only person that came in and say, look, I want to speak on behalf of Amber Heard and the things that she has suffered is her own blood sister and nobody else. I mean, that's insane. Lisa says, this is so bad, Larry. What do you predict the appeal judges will do? Well, let's finish this first, Lisa. Ask your question again at the very end, because we have a lot more to cover before we get there. The lack of compulsory process meant, first, that the only live fact witness Heard was able to call in her defense was her own sister, Depp, who has considerable resources from his decades as a movie star. Wow, you're using the movie star defense. Okay. Wow, very low blow. You even know it's a low blow, because just because he's a movie star does not mean that people are going to come to his defense just because of that. That's ridiculous. That is absolutely ridiculous. But okay, they're making it. It's right there. It's written. It's submitted. It's part of the record. You can't undo it. He was able to call more than 15 live fact witnesses who voluntarily traveled to Virginia from another jurisdiction or appeared by WebEx I think they're referring primarily to the driver, a few others, and of course Kate Moss, many of whom are employed by or otherwise financially linked to Depp. Well, Amber didn't have the financial means to have her own posse, so that's a you problem, again, as we like to say in the business. But they testified under oath unbiasedly. Depp capitalized on that disparity, arguing to the jury that you may have noticed that no one showed up for Ms. Heard in this courtroom other than her sister. Other than a witness who traveled to Virginia for her as a paid expert, this is a woman who burns bridges. Her close friends don't show up for her. The truth hurts. The truth hurts. If the sister's there, yeah, where's the dad? Where's the mom? Where's the rest of the family? Showing support. Second, the lack of compulsory process. Again, we couldn't grab people by the throat. So therefore, she suffered. Terrible argument. Second, the lack of compulsory process prevented Heard from responding as Depp shifted the case. While Depp was able to redirect witnesses and call new previously undisclosed witnesses in rebuttal, Heard was reliant on video deposition testimony. Again, I don't think the judge made a ruling that, oh, Ms. Heard, you're only permitted to call in deposition witnesses. That's bullshit. No judge in the universe, including Judge Escarati, would have ever made an argument like that or entertained an argument like that and ruled in the favor. You can call witnesses so long as they are relevant to the case and have something to say that is not going to be just pure hearsay and distract from the jury or be prejudicial to the other party. I mean, there are obviously still certain rules that are in place. However, you can't just call everybody on the planet and hope something sticks and waste the court's time. Because don't forget, at the end of the day, Judge Ascarati put both of them on the clock. Both sides had a limited number of days or hours to use. And once those hours expired, you're done. You have nothing else. You can argue that on appeal, and I'm surprised they're not making this argument, you could argue that Judge Ascarati putting time limits on the parties would have has prejudiced them. But I think that is actually the weakest argument because they had plenty of time. Both sides had an enormous amount of time to put forth their case, and to argue that it was not enough time to present their case or the defense is extremely weak. Hey, Laura B's in the chat. How are you, Laura? She said, how can she claim shortage of witnesses for her when the insurance was paying the costs? Curious, Laura. Very, very good point that you bring up. Insurance is paying for it. I mean, the counter to that is, well, the insurance is paying, but they still can't take time off of work and come in to testify on my behalf and my defense. Still a terrible, terrible, terrible argument. So yeah, money talks, bullshit walks. She had plenty of money. She just didn't have any friends. Sorry, I said it. Tell me I'm wrong. Tell me I'm wrong. Yeah. Thank you, Laura B, by the way. I salute you for all the work that you have accomplished. Okay. This is precisely the kind of disadvantage the doctrine of forum nonconvenience is designed to prevent, which is true, but it just doesn't work in this case. The trial court abused its discretion in denying Heard's motion to dismiss, and this court should now reverse and dismiss this action without prejudice. Okay. Notice, by the way, this is very, very important. This is very, very important. They keep using this language. Dismiss the case without prejudice. Dismiss the case without prejudice. What does that mean? There are two ways to dismiss a case: with prejudice and without prejudice. If you dismiss a case without prejudice, basically you overrule the district court and you say, or this, excuse me, in this case, the circuit court, and you say, look, you made a mistake. We agree with the defendant's arguments that this should have been dismissed, and we are reversing the judgment. Basically, nobody wins. Go back, and we're dismiss. It should have been dismissed without prejudice and brought back in the proper forum, which is California, let's say, for example, right? That means the lawsuit would literally begin anew. You would start again, complaint, like comity, double jeopardy is only in criminal cases, but essentially it would be double jeopardy here as well. At the bottom line, that's what it would look like. And you would start the case in California. That's what they're trying to argue. Because if they have been arguing that you should have dismissed this case with prejudice, it means that's it, boom. You put a big red giant X on the case is over. Case is done. Call it a day. You lose, go home. It's over. No more. That's dismissal with prejudice. Dismissal without prejudice allows the case to be brought back again, start to finish, in the proper forum. That's why they keep using this language, in case some of you were curious. Okay. All right. Part 2 of argument number 1, why the trial court should have dismissed DEPP'S claims. The trial court should have dismissed DEPP'S claims because the challenge statements are non-actionable expressions of opinion. Expressions of opinion are constitutionally protected and are not actionable as defamation. That is true. Statements that lack a provably false factual connotation or are relative in nature and depend largely upon the speaker's viewpoint are expressions of opinion. They're citing case law. Like, all of this is true. Wait until they start tying it in. Let's see. Whether a statement is an expression of opinion is a question of law that is reviewed de novo. So now we have a brand new standard. Up until now, it's been abuse of discretion, whether or not Judge Escarati abused her discretion. That is the standard of review for the previous point. For this point, the standard of review for the Court of Appeals is different. It is known as de novo. De novo means you ignore what the judge did and you look at it as if it's a brand new, fresh. We don't care what the judge did. The judge did this. Look at the law. This is what you should do because this is what the law says. That's what it means to look at a case de novo, a de novo review. It's Latin for anew. Some of you who speak Spanish may recognize it's got the same root. Nuevo, de novo, nuevo. Nuevo is new in Spanish. Language is so fascinating. Wait, that's it? It's that short? It's like barely, okay, hold on. Seriously? What I thought was one of your strongest arguments, you're going to use a paragraph for? The 3 challenge statements, with the exception of the portion of the headline stating I spoke up against sexual violence, which obviously is true, are protected opinion. There is no objective basis for asserting the truth or falsity of whether Heard felt or faced her culture's wrath, whether she's a public figure representing domestic abuse, or whether she saw institutions protect men. These statements are relative in nature and reflect Heard's subjective viewpoints. The trial court violated its essential gatekeeping function by allowing the jury to consider those non-actual opinion statements. The end of that argument. Are you kidding? So the good. Oh, I'm sorry. Her mom is deceased. I apologize. I can't keep track of the. I know Johnny's mom is deceased. Now I forgot. I'm sorry if I said that. I did not mean anything bad by it. I apologize. But family. Okay, let me just broadly say family. She has cousins. She has uncles. She has aunts. She has nieces and nephews that could potentially come in and like maybe bring something to the table if possible. I don't know. So none of them came in except her sister. Whew. So, wow. The opinion argument, which I thought they're gonna like hang their hat on. I could have sworn when I was reading the errors on appeal, I think I even said this in the video. That was one of their, you know what that tells me? The reason that they did not put their hat on this argument is there's not enough case law to support that it's an opinion. And it's pretty clear that it's not an opinion. It's not easily verifiable. That's basically what it is. If you can easily verify, that's kind of like, it's a very loose definition. I'm trying to like break it down as to as simple terms as I possibly can. But essentially, if you can easily verify that whatever is being said is as true or fact, like let's say, we already talked about this previously, but I'm going to bring it up because it's extremely relevant. I posted a video of a police officer planting evidence one time. He sued me for defamation, arguing I didn't do that. I posted the video of him doing it, and he sued me for defamation. I won. The judge agreed with me. The judge said, look, the bottom line was, it was easily verifiable. One could look at the video. You didn't have to read Mr. Foreman's statements. You could look at the video and determine independently, did this happen or did this not happen? If you have an ability to independently verify whether this is the test, opinion or non-actionable opinion or actionable non-opinion, okay? That's the test. The judge it was Judge Cunningham here in Circuit Court Division 4 in Jefferson County, wrote a beautiful opinion. He said, it's easily verifiable. Remember that as being the standard for opinion. Is it easily verifiable that, then this is like the First Amendment. Remember, in her tweet before she shut it down, her last tweet, Amber's last tweet, she talked about my First Amendment for speech. I'm allowed to speak opinion. If it's easily verifiable, they spent a quarter of a page, a quarter of one page or half of one page total on Amber's tweet. You can't make this shit up. You cannot make this shit up. They spent a half a page, the whole tweet, her whole argument in the tweet that I was not allowed to give my free speech, they've spent 1% of the brief on. 55 pages, this is half of a page, this is 1 out of 110. It's actually less than 1%. It's 1 out of 110. 1 page out of 110, essentially, if you want to look at it. Half a page out of 55. That's how you calculate percentages. You try to bring it up to 100. Jesus Christ. Non-actionable opinion. Well, the problem is you can't easily verify the statements. That's the standard. Remember it. Easily verifiable. And that's why I won my defamation case. And that is why Amber is probably going to lose her appeal on Johnny's win of the defamation case. Helena B. Garanci says Elon Musk was an unwilling witness and a literal billionaire. What's her excuse now? Was he subpoenaed to the case? I don't know. I don't know. Okay. So, wow. Okay. Argument number 3, under the umbrella argument as to why it should have been dismissed. The trial court should have dismissed DEPP'S claims, and this is our third reason, because the challenged statements are not reasonably capable of conveying a defamatory implication as a matter of law. This is the implication argument. When a defamation claim is based on the allegation that an otherwise non-actionable statement conveys an actionable implication, the alleged implication must be reasonably drawn from the words actually used. A plaintiff may plead innuendo to show how the words used are defamatory and how they relate to the plaintiff. But innuendo cannot introduce new matter, nor extend the meaning of the words used, or make that certain which is in fact uncertain. It is not the province of an innuendo to enlarge the meaning of the alleged slanderous words. This comes from a case. Its use is to explain matters already expressly alleged. Now, whether a statement is reasonably capable of a defamatory meaning ascribed to it by innuendo is a question of law to be reviewed de novo. So there is that standard again. This is not abuse of discretion standard. This is a de novo standard. We look at it anew, de nuevo, de novo. It is undisputed that the op-ed does not mention DEPP'S name or the party's prior relationship. Literally, that is true. Describe the 2016 restraining order, or discuss Heard's statements or evidence in that proceeding. Rather, the op-ed advocates for changes to laws and rules and social norms regarding domestic violence and sexual assault, so that women who come forward to talk about violence receive more support. Notwithstanding the absence of any express reference to the allegations underlying the 2016 proceeding, Depp's position is that the op-ed implies he abused Heard because reasonable readers would understand the words, "2 years ago, I became a public figure representing domestic abuse," to refer to that proceeding. Depp contends, in other words, that Heard revived her 2016 allegation simply by describing in the op-ed the public backlash she faced after obtaining the restraining order. Depp's theory of liability extends the meaning of the words used beyond recognition. And that's where I think the argument starts falling apart, because celebrities are unique creatures in that regard. Celebrities have a status that is reserved for them specifically, that is, celebrities. There are even dating apps now, I have heard of at least one, that is exclusively reserved for celebrities, so that celebrities can meet other celebrities. I don't know what the criteria is. I don't know what the qualifications are to join that app. I frankly don't care. But I know that they have a certain status. Why? Because they have millions, sometimes tens of millions, sometimes hundreds of millions people who know who they are. They know their name. They know what they look like. They know what movies they've been in. They know what they authored. They know what the list goes on. So the fact that Amber took to the stage in December of 2018 and authored a piece stating that, look, I spoke up against sexual violence and this needs to be addressed and blah, blah, blah. People looked at that and went, wait a minute. Publicly, Amber Heard, also being a celebrity of some stature at the time, because she was about to premiere in Aquaman, and her name and face were definitely on the public sector, in the public sphere. The argument that as a celebrity, she was talking about, like, who is she talking about? Is she talking about Johnny, or is she talking about somebody else? In the public sphere, it was 99.9% of the world pointing the fingers at Johnny when that article went viral. And that is why this argument is going to fail. Defamation by implication is an argument, but it's an argument when the speaker and the writing about, or excuse me, the writing and the person it is supposedly written about has to have some causal connection between the two. And how easily is it verifiable to a passive observer? If it could have been, like, let's say she has been in 5 marriages. Okay, let's change the facts for a minute. Let's say Amber was in 5 marriages, each lasted 2 years, and they all started in like 2008, okay? 2008 to 2010, 2010 to 2012, marriage, divorce, 2014, 2016, and 2018, and then she authors this piece. This would have been a completely different case. Because now, who is she talking about? She has been in 5 marriages. They were all public. Everybody knew about them. Everybody heard about them. And all of a sudden, she authors this piece. Oh my God, who is she talking about? Is it the 2008 husband? Is it the 2010 husband? Is it the 2012 husband? The 2014 husband? No, this is not a fact, okay? So coming back to the real facts of this case, in 2016, she files the TRO, and then 2 years later, she authors the piece, the entire world looking at it, and they go, oh, well, obviously, we know who you're writing about. It's not a question for interpretation and go, all right, we have several options. Maybe it's somebody else. And especially the fallout that Johnny Depp experienced as his witnesses testified as a result of that piece being written. Everybody knew it was directly about him. So this argument is not very strong at all. They're making this argument. Depp's theory of liability extends the meaning of the words used beyond recognition. And I respectfully disagree. The reasoning in Fairfax v. CBS is illustrative. In that case, okay, so now they're comparing. They're trying to show that case is similar to this one. Let's see. In that case, the court considered whether the hosts of a television news program defamed former Lieutenant Governor Justin Fairfax while interviewing two women who had accused Fairfax of sexual assault. The court concluded that Fairfax had failed to plead defamation by implication because the hosts had not stated that Fairfax did, in fact, commit the alleged sexual assaults. And the challenged commentary did not ascribe to any particular view of the underlying events, but rather focused on how persons who believe they are victims of sexual abuse are affected. So they're interviewing these two women in that situation. They're interviewing these two women, and these women say, oh, Mr. Fairfax, they accused him of sexual assault. And Fairfax then sued the television news program. He sued CBS where this aired. But how is this different from this case? Here it is. They did not focus on the victims. Here, it is clearly the focus is on Amber as the victim and this mysterious, right? Mysterious in quotes, perpetrator of the sexual violence. I see how they're trying to make the parallel, but it is very, very shaky. Very, very, very shaky. Almost completely different. Like it takes a minute to process, you guys. You'll have to excuse me as I'm 100% doing this in real time. Normally, I would be given like an hour to read and brief this in the real world. Doing this on the spot is not as easy as it looks. But I will say right now that the facts are different because Amber, don't forget, Amber authored the piece, and the piece went public without naming Johnny, okay? Not directly. His name was not in the piece, but the implication was everybody immediately concluded, oh, this is written about Johnny. Here, they directly said, this is about him. But the news program was like, you know what? We're not talking about him. Let's talk about sexual abuse and victims of sexual abuse. But we're not going to, we personally are not alleging. The Lieutenant Governor, Justin Fairfax, former Lieutenant Governor Justin Fairfax, if he had sued the two women for uttering those statements, now that would be defamation. He didn't go after them because they probably didn't have any money. He went after the news network because they do have money. There you go. There you go. There's the answer. I just figured it out. You're welcome. So I see why they're trying to make the parallel, but actually the case falls. The case fails on its face. Similarly, in the op-ed, Heard did not recount the events underlying the domestic violence proceeding. Rather, she discussed how women who allege domestic violence are treated by society, and she advocated for changes to relevant laws and social norms. To accept, as the trial court did, Depp's assertion that a reasonable reader could understand the op-ed to imply that he abused her merely by describing the public reaction or allegations would be to create a rule preventing any abused person. Now the slippery slope argument is clicking in. You guys smell it? You guys smell it in the air? Would be to create a rule preventing any abused person from addressing the societal implications of speaking out about abuse, which is not true. We just addressed it. It's because they're both celebrities, one more so than the other. Of course, talking about Johnny Depp. But that's not the point. The point is they're both in the public eye. The implication is so much easier to see. The force of the implication is going to play a huge role. And so far, it is clear. In our case, it is clear. If that were the law, there's the threat. Then it would be actionable in defamation to say, well, 4 years ago, Christine Blasey Ford became a public figure representing sexual assault. That is plainly not the law. Now, again, that is beyond slippery slope. This is trying to allude to something that could potentially happen, which is Has not happened and will not be happening, but they're trying to make it look. It's like a commercial. It's kind of this reminds me of. It's like a commercial. Like, when was the last time that you experienced a scratchy beard? Like, use this oil, which you absolutely need now. And you're like, I have a beard. I don't have. It's never been scratchy, but it could become scratchy in the future. Maybe I should get that oil. That's not that. This is literally how commercials work on you. Tracy Haverstick says, I have a hard time swallowing anything they're saying because I witnessed and heard with my own ears both abuse Johnny Depp and admit she wrote it about him. There you go. There you have it. Okay. Let's keep going. The trial court's ruling also contravenes the doctrine of judicial privilege. The statements Heard made in the course of obtaining the restraining order were absolutely privileged. Shouldn't this be its own headline? I mean, you are just completely shifting gears here to judicial privilege? The statements Heard made in the course of obtaining the TRO are absolutely privileged? You mean that is after she tipped off TMZ to come in and... Huh? Karen Lodge says, would JD have insurance and used it as well? Maybe. I don't know. No one has been talking about it. Welcome, Beautiful Disaster, to the channel. Don't forget to like this video, comment below, subscribe to the channel if you haven't already. All right, let's see. Permitting a claim for defamation by implication premised on a person's published statement about her experiences in the aftermath of a judicial proceeding would substantially undercut the public policy. Great. Now you're arguing public policy? In your first argument, now you're going to policy. You have lost all case law on the issue. You don't have any good case law on the issue. So you're like, all right, it will be terrible public policy. See such and such case. Would undercut the public policy served by the judicial privilege. In overruling Heard's demur on the issue, the trial court relied primarily on Pendleton, a defamation action brought by the mother of a student who died at school from a peanut allergy. The mother alleged that school officials had made statements to the public and the press in response to the incident implying she was to blame for her child's death. For example, an official said that the school's trained professionals can only be effective if a parent provides information, doctor-prescribed health plans, and the medicines necessary to carry out those plans. Unfortunately, this does not always occur. The Supreme Court held that these statements were reasonably capable of conveying the defamatory implication the mother alleged. So in that case, again, obviously, who are they talking about? They're talking about the mother. So that's a fairly straightforward and easy case. But unlike here, the statements at issue in Pendleton were in direct response to questions about the child's death and asserted that a parent's failure to communicate key information about an allergy impedes treatment of allergic reactions. Thus, the words used by the defendants readily implied a causal relationship between the child's death and her mother's actions or inactions. And again, I'm falling back on the whole, they're celebrities. They have no private life. Everything that they do, every move that they make, every move you make, every vow you break, TMZ is like, I'll be watching you and posting about it on the internet and writing everything and showing all your videos and showing all the photos. That's the problem. That's why this argument fails. Sure, it's a lot easier to show a causal connection between a mother and her child than it is between a network and a defamatory statement, but when you're a celebrity, your whole life is in the public's eye. So when somebody says something and it looks like they're talking about somebody, and there's no question about who that somebody is, it's not the 5 husband example that I gave. It's we had one. In stark contrast, the op-ed does not refer to Depp or say anything at all about Heard's abuse accusations or the judicial proceedings in which she obtained the TRO. The trial court improperly allowed Depp to use innuendo to enlarge the meaning of the alleged slanderous words in the op-ed. Respectfully disagree. In post-trial motions that Heard has made, and the trial court erroneously rejected, a related point. The trial court should have held that a plaintiff cannot recover for defamation by implication where the alleged implication is based on statements that are true on their face and involve a public figure or a matter of public concern. But again, true on their face? How? How are they true on their face? Because of Amber Heard's testimony? Then they're not true on their face. How can you say this? It's based on statements that are true on their face. Objection, speculation. Objection, proven false by testimony. Golden nugget number 6. Statements that are true on their face. That's not true. She lost because the jury disagreed and said, no, they're not true. And therefore you defamed Johnny. Seriously? Matthew Lemoyne says, the implication is easier to make, but also it is a lie. If it was the truth, it would not be actionable. Exactly. And by the way, for those of you who don't know, there is an absolute defense to defamation. If you are ever sued, not you personally, but generally speaking, ever sued for defamation, truth is an absolute defense. Your Honor, this is true and here are the facts. The easiest backup argument we already mentioned, it's the easily verifiable facts. Just look at the video or the photo or the article that cites to all this blah, blah, blah. As long as you have it. If you have it. You don't always have it. Like here, there was no proof either way. Julie Gibson says, Larry, just out of curiosity, how many pages are Johnny Depp's team allowed in response to this mess? There is so much ridiculousness for them to address. I believe the response allows for about the same number of pages. It's 50. It's 50, if I remember the rules correctly. And they've already pre-asked for an extension of time and pages. And the court, remember, said, no. We're going to address it when the time comes. So just kind of sit tight. Let's wait for the brief to come in first, and then you can do whatever you need to do. And if you need to refile your request, you're more than welcome to. And Amber's team has already not objected. So they may re-object to the new one. They may not. I don't know. That's a fantastic question. Thank you for bringing it up. They have plenty of space. Don't worry about Camille Vasquez and Ben Chu. They'll take care of this crap. Honestly, don't worry about them. If I, sitting in front of a camera on my computer, can pick it apart, so can they. I mean, please. They're much more legally knowledgeable and much better equipped to address these things than I am. And I'm literally doing this in front of a microphone. So think about that. Think about that. In post-trial motions, Heard made and the trial court erroneously rejected a related point. Did I already read this? Should have held the plaintiff cannot recover. Yes. Okay. In a matter of public concern. Defamation by implication or innuendo is actionable only if the statements regard a private individual in private affairs. Statements about public figure that is true on its face cannot support a claim for defamation by implication. Same. Okay, so some jurisdictions are like Louisiana, we have Minnesota, New Mexico, Colorado, New Jersey. All of these cases are like, Only actionable if it's a private individual, private affairs. And Virginia is maybe taking a minority view. I don't know. It really doesn't matter. It's going to be up to the courts to decide. Courts in other states, here it is, have similarly limited claims for defamation by implication by a public figure where the defamatory inference arises from the omission of material facts in the challenged communication. That's actually a stronger argument to argue that it should only apply to public figures, to private figures and not public figures. Maybe, but that means the Court of Appeals of Virginia would have to either apply this law universally now, starting today, and it may still not be enough for them to win because the court may say, well, look, we can change the law now, but up until this point, we're happy with it. Or they can say, we're not changing, or we're not creating, we're not agreeing with you, we're not agreeing with all these other jurisdictions either way. So anything is possible. Anything is possible there, no question. The court should adopt the same rule here. So there they go, asking the court to adopt these rules. To further the public interest in speech on matters of public concern, including speech about how segments of the public react after someone makes allegations of abuse, and hold that Depp failed to prove defamation by implication because he did not prove that the statements are false on their face. And again, the judges are going to look at this and they're going to go, okay, what do we have? We have a very public trial with a very serious allegation, with a very direct hit to a person's reputation, a very serious accusation on the other side. You have defamed me. It's a defamation case, and applying it only to private figures may not be the best result that we want universally across our great state. So we're just going to keep it. We're going to allow public figures to do it. We're not going to limit it to private figures. It's a very, very simple, easy, direct way for the judges to just keep moving forward, to keep things moving forward. It's actually a very, I wouldn't say complicated, but to someone who does not practice law, it may be a little difficult to wrap your head around it. So don't feel bad if you don't get it. Honestly, it even took me a second to try and figure out what exactly it is that they're trying to do. It's not a cut and dry, boom, boom, type of thing. It's a very, very lawyer thing that they're doing here. So finally, we have at least a little piece. They're swaying the court. They're saying, look, we should change it, but the underlying facts are not good. We always say, like, bad facts make bad case law. Bad facts make bad case law. When you appeal terrible cases, you have judges who are like, you know what? We could have gone this way, but because your facts are so shit, we are going to go that way. It happens all the time, and lawyers know it. And then we secretly inside yell at other lawyers going, oh my God, why did you appeal this case? It was a loser, terrible case. Why did you do this? So this is one of those examples once again. Ensuring that defamation suits proceed only upon statements which actually may defame a plaintiff, rather than those which merely may inflame a jury to an award of damages, is an essential gatekeeping function of the court. The trial court failed to fulfill that role, and this court should reverse and dismiss the claims because Depp cannot make out a claim for defamation by implication as a matter of law. Number 4, as to why Depp's claims should have been dismissed. The trial court should have dismissed Depp's claims because this is still argument number 1, by the way. For those of you who just are joining us, this is still argument number 1, point number 4. The trial court should have dismissed Depp's claims because the doctrine of issue preclusion prevents the relitigation of the UK court's ruling that Heard's abuse accusations are substantially true. And this is by far their weakest argument of all. Issue preclusion, which is a thing, but it's usually a thing across states, not across countries. It can be, but it has to be so substantially similar to bar relitigation. Essentially, you're saying like, look, I didn't get a favorable ruling here, so let me try here. Maybe I can win here. Tracy Haverstick says, Larry, will it matter that immediately following the verdict, Elaine and Amber went on TV and continued to attack Johnny? No, not at all. Judges don't care about that. Beautiful Disaster, best response to, but his name wasn't mentioned, Mr. Hollywood. But did she have another husband in 2016 who abused her. Exactly. You got it. Issue preclusion bars successive litigation of an issue of fact or law actually litigated and resolved in a valid court determination essential to the prior judgment, even if the issue recurs in the context of a different claim. The public policy underlying the doctrine is to relieve parties of the cost and vexation of multiple lawsuits, conserve judicial resources, and by preventing inconsistent decisions, encourage reliance on adjudication. Put differently, one adverse litigative adventure on any issue is enough for any one litigant. Such colorful language, and yet it means absolutely nothing in this context. To establish issue preclusion, a party must show that the relevant factual issue was actually litigated in the prior proceeding, that it was essential to the prior judgment, and that the prior proceeding resulted in a valid final judgment against the party against whom the doctrine is sought to be applied. In certain circumstances, the party asserting issue preclusion also must show mutuality, i.e., that the parties to the two proceedings are the same or are in privity to one another. The Virginia Supreme Court has recognized the mutuality doctrine should not be mechanistically applied when it is compellingly clear from the prior record that the party in the subsequent civil action against whom collateral estoppel is asserted has fully and fairly litigated and lost an issue of fact which was essential to the prior judgment. But again, golden nugget number, what are we on? 6, 7? Where are we at, chat? They just admitted that the parties to the two proceedings are the same or in privity to one another. They're not the same, that's clear. The sun does not equal Amber, Amber does not equal the sun. In privity to one another? How? How are they related? One is a newspaper, the other is a person. In their different jurisdictions, in two different countries with two different standards. There was no jury in the UK. It was the judge. Nicholas Stero says, I see only circular arguments with all weak links. Each one of the arguments only hold validity if the rest of the arguments holds for scrutiny. Very beautifully said, Nicholas. I agree. The traditional rationale for mutuality does not apply when issue preclusion is asserted defensively, that is, when the defendant, a stranger to the prior proceeding, attempts to preclude a plaintiff, a party to the former proceeding, from relitigating an issue plaintiff lost in the earlier case. And this is, by the way, applying a United States case to another United States case, not United States to United Kingdom, where the plaintiff has already had his day in court with the opportunity to produce his witnesses. And this is what they call forum shopping. It's like, I lost in California, well, let me go litigate in Virginia. I lost in Virginia, all right, let me try Minnesota. I lost in Minnesota, okay, let me try Florida. You can't do that, and for these reasons exactly. But nothing precludes you from suing a different defendant in a different country, even though the issues may be similar, but not the same. The traditional rationale for mutuality does not apply when issue preclusion is asserted defensively. Where the plaintiff has already had his day in court with or her, with the opportunity to produce his or her witnesses, to examine and cross-examine the witnesses for the other side, and to appeal from the judgment, there is no sound reason to allow him a second bite at the apple. Literally what I just said, the California to Virginia to Minnesota to Florida. Whether an issue is precluded by a prior judgment is a question of law for the appellate court to decide de novo. That's the standard. Once again, de nuevo. The UK judgment meets all the requirements for non-mutual defensive issue preclusion against Depp, yet the trial court erroneously required mutuality. There is no dispute that the truth of Heard's abuse allegation was actually litigated and essential to the prior judgment in the UK proceeding. The Sun published an article calling Depp a wife beater, and Depp sued the Sun, alleging that it defamed him because the abuse allegations were false. In rejecting Depp's claim, the UK court found, by itself, one judge, based on much of the same evidence presented in this case, Depp versus Heard's testimony, that Depp had engaged in at least 12 acts of domestic violence against Heard, causing Heard to fear for her life. The UK court therefore concluded that the defendants had proven the Sun's description of Depp as a wife beater was substantially true. Again, the reason why it's a terrible argument, it's a very, very different standard of review. It is decided by a judge, not by a jury, and the rules are different. So it's apples and oranges here, and two different defendants too. So it's a nice try, but it's not going to withhold muster on appeal. There is no question that Depp had a full and fair opportunity to litigate this issue. Some minds may differ. Depp chose to file a libel suit in the UK predicated on the same abuse allegations that he contends were revived by Heard's op-ed. Indeed, Depp's UK counsel asserted prior to trial that his client could only be vindicated by a clear and reasoned judgment from the UK court. Okay, that's fine. Things change. The parties to the UK proceeding engaged in extensive discovery and motions practice, and Depp also had access to the discovery conducted in this case for 16 months prior to the UK trial. They keep coming back to the whole, he had the discovery. The UK trial included 4 days each of testimony by Depp and Heard, as well as 24 other witnesses. And under UK law, Depp faced a much lighter burden of proof on his claims than he did in Virginia. And again, I wholeheartedly disagree, but they keep saying it's a lighter, it's substantially similar. I keep forgetting the language. We read it in one of the briefs. Help me out, chat. Maybe you can give me, I need an assist. I'm calling a lifeline, calling the chat. Under UK law, Depp faced a much lighter burden of proof on his claims than he did in Virginia. In the UK, the defendants bore the burden of proving the substantial truth of the statements rather than Depp having the burden of proving them false. Yet Depp still lost and exhausted his appeals. Thank you for the super sticker, Kelly D. Anyway, while you guys are looking for that, it's the standard of proof. It's very similar in Canada. Canada and UK, if you all don't know, by the way, Canada is basically UK light. They both have the same standard. It's not, so we have, ours is called preponderance of the evidence, and theirs is called balance of probability. Thank you. Yes, the balance of probability. And there is a question. There is definitely a question as to which one is higher, which one is lower. I think, honestly, it is almost exactly the same. Maybe a little starker, maybe a little lighter, but that doesn't matter. Again, that doesn't matter. It's just 1 point in the equation. It is 1 point in the equation on a single judge. Exactly. Exactly. So balance of probability, preponderance of the evidence are very, very similar standards. So by saying a much lighter burden of proof, without even naming it, like what it is, the UK judgment is entitled to comity for purposes of issue preclusion. UK law is reasonably comparable to Virginia law. Indeed, as noted, it is more favorable to Depp because he had no burden to prove falsity. Having voluntarily filed suit in the UK court, Depp has no basis to argue that the judgment is not deserving of recognition. Okay, all right. This is the argument that you're making. In short, Depp had his day in court in the UK proceeding, and he should have been precluded from relitigating the exact same factual issue that was decided against him in that action. Accordingly, this court should reverse and dismiss Depp's claims. We have an asterisk. The trial court also erred in holding that Heard was not in privity with the son with respect to the factual issue of the truth of her abuse accusations. Privity exists where a party's interest is so identical with another. So are you saying Amber Heard is identical to the son in that sense? That's a very interesting argument, but it's not strong at all. So identical with another that representation by one party is representation of the other's legal right. During the UK proceeding, Depp argued that his effective opponent was Ms. Heard. This is the argument that they're making. Okay. So that's point number one as to why it should have been dismissed before we even got to it. So far, I am not very impressed. They had a few little nuggets of their own. I'm not talking about our 6 golden nuggets or 7 golden nuggets that we have collected so far. I mean, there is potentially they could have made some of these arguments stronger. They may have run out of space because they wanted to argue some other things. I don't know. But so far, I'm not impressed at all. They don't have force. They don't have panache to ask the judges to overrule the opinions of and the decisions made by the judge below. They just don't have force behind them. And for an attorney who does this for a living, I can tell you, when you're arguing a court of appeals brief, you want to have as much force behind it as you possibly can, the force of law. And they have some. I will give it to them. They absolutely have some, but it's also got to be strong. You can't simply lay it out and just kind of like butter it up and then serve the buttered toast to the judges. You need more. You need more. It has to be convincing. It has to make the judges read this and go, maybe they're right. Something has gone wrong here. But remember, I said when you start with a pile of shit, it's very difficult to make that pile of shit look attractive. Because if you put sprinkles on it and you put it in a beautiful bowl and, you make it very presentable, at the end of the day, it's still a pile of shit. That's the problem. But let's see if they have 2 more arguments to make. Let's see what they can do. Nicholas Stero once again says, the only time I've heard of a judgment carrying over is when someone asks to transfer jail time from the US to Sweden, but that is only criminal cases. Okay, that's cool. Thank you for sharing that. You can't polish a turd. Yeah. And by the way, I remember it. It was Jeff Dunham. Remember that joke that I made and I couldn't remember who it was many, many, many streams ago? If you polish a turd, it's still a turd. It was Peanut. It was his character, Peanut, Jeff Dunham's character, Peanut, saying that. Anyway, moving on. Argument number 2. The trial court erred in denying Heard's motion to set aside the jury's verdict based on Depp's failure to prove actual malice. Okay, so we just jumped from pre-litigation, it should have been dismissed because of reasons 1, 2, 3, 4. Now We're done with that. We're going to argument number 2 in Amber Heard's brief as to after the trial, it should have been, the jury's verdict should have been set aside. Now here we are. We skipped the entire trial, which is, again, not uncommon. These are the arguments that they're making. These are the arguments they chose to make. I didn't pick this. They wrote this. The trial court erred in denying Heard's motion to set aside the jury's verdict based on Depp's failure to prove actual malice. And the AOE, by the way, that you're seeing, if you're wondering what that is, that's the assignments of error, which numbers they are, because they have to be preserved. If they're not preserved, you can't argue them. Both under First Amendment and as a matter of Virginia state law, Depp, as a public figure challenging statements to the public on a matter of public concern, was required to prove by clear and convincing evidence that Heard made each of the challenged statements with actual malice. Absolutely true. That's the standard. Actual malice is a term of art that means that the defendant either knew her statement was false at the time that it was published or published it with reckless regard for the truth, i.e., it was subjectively entertained serious doubt regarding its truth, but published it anyway. In defamation by implication cases such as this one, establishing actual malice requires making a second showing. Not only was Depp required to show knowledge of or recklessness in regard to the falsity of the statement's defamatory meaning, but also he was required to demonstrate that either the defendant intended to communicate the defamatory meaning or knew of the defamatory meaning and was reckless in regard to it. Without this requirement, a defendant could be held liable for what was not intended to be said, which would eviscerate the First Amendment protections. Recognized by the U.S. Supreme Court, Simply because a statement reasonably can be read to contain a defamatory inference does not mean that the publisher of the statement either intended the statement to contain such a defamatory implication or even knew that the reader could reasonably interpret the statements to contain the defamatory implication. So this is the law. They're outlining for the judges the relevant law on this case. Whether the trial record is sufficient to support a finding of actual malice is a question of law, and this court must make an independent review of the record. Judges must independently decide whether the evidence is sufficient to cross the constitutional threshold that bars the entry of any judgment that is not supported by clear and convincing proof of actual malice. Significantly, in deciding this issue, this court must evaluate the record in light of Depp's burden to prove the two prongs of actual malice by clear and convincing evidence. And now their argument, Depp failed to meet that burden, and therefore this court should reverse and enter judgment for Heard. See also some cases here cited, so we're not going to read those because they're just cases. All right. Part A of argument number 2. Depp failed to prove by clear and convincing evidence that Heard was aware of and intended to communicate the alleged defamatory implications. A person cannot knowingly or recklessly tell a falsehood if she did not intend to and was not aware that the words she used would be understood to communicate such a falsehood. So wait, now intent is a factor? A person can't knowingly or recklessly, if they did not intend, right? Recklessly, you still can. It's called recklessness. You didn't intend to, but you recklessly did so. So that statement by itself is a misnomer. But okay, let's see what else they've got. The evidence at trial fell far short of establishing by clear and convincing evidence that Heard had the communicative intent to accuse Depp of domestic abuse in the op-ed. The undisputed evidence showed that the ACLU proposed that Heard author an op-ed on the ways in which survivors of gender-based violence have been made less safe under the former presidential administration. The ACLU then prepared the initial draft of the op-ed. HERRED engaged her attorneys and, based on their advice, made significant efforts to remove all references to Depp and their marriage from the draft. Golden nugget number 7, you guys. So the draft did include him. So it was about him. Is this a joke? Did they just admit that of course it was about him? We just had to make sure to remove any references to him. I can't. You can't make this up. Nicholas again says, if there is case law on that, say the Supreme Court of the United States, then the UK trial argument fails on precedent. Sorry, I had to Google some words. No, you're all good, brother. Thank you for your participation. I'm loving this. Crime and crochet are my hyper focus. Just tweeted you a short link for search showing how the op-ed implicated Johnny as the subject chronologically. She did not have to name him directly. Oh my God. Look at it. I'm going to read it again because this is ridiculous. The ACLU prepared the initial draft of the op-ed. HERRED talked to her attorneys and, based on their advice, made significant efforts to remove all references to Depp and their marriage from the draft. So I spoke about sexual violence in reference to my husband, but please let's take him out as much as we can so that people don't realize it's definitely about him. How is... But... Retired Nana says, in court, JD attorney had something that Amber wanted it to be spicier. We are only halfway through it. This is unbelievable. I can't. It's days like these, it's moments like these that make me wish I could have a mega pint. But I don't want to, since I don't drink by choice. I'm actually going to be celebrating 4 years in 2 weeks. I haven't posted about it in a while. I figured I'm just going to wait until the big day, which is the 12th of December. So super excited about that. But this is crazy. This is nuts. They're making admission after admission after admission after admission. It feels like they just gathered a bunch of paralegals and were like, and go. And then nobody proofread it. HERRED engaged her attorneys and, based on their advice, made significant efforts. I'm reading it for the 3rd time because this is the biggest thing of them all. They're saying it wasn't about him. There's no reasonable implication it was about him, but it was about him. We just have to make sure that nobody knows it's about him. Significant efforts, says Julio, tells me it had his name all over it in the first draft. That's how I'd read into the lucky number 7 golden nugget. Yeah. This is like the diamond nugget, you guys. This is the diamond nugget. This is diamond nugget number 1. We just found diamond in the raw, diamond in the rough, out in nature. Lisa, thank you for the super sticker. Straight up. Heard engaged her attorneys and, based on their advice, made significant efforts to remove all references to Depp and their marriage from the draft. Okay. Thank you. Thank you all for coming. It's been a pleasure. My name is the DUI guy. No, I'm just kidding. We can literally just end right here. As Heard explained, the purpose of the op-ed was not to discuss Depp or the particular allegations she raised in 2016, but rather to discuss what happened to her in the public arena after she spoke out. In sum, Depp presented no evidence, much less clear and convincing evidence. Remember, I said this is another way of saying jury got it wrong. Heard either intended to communicate through the op-ed that Depp had abused her or knew of the defamatory meaning and was reckless in regard to it. Indeed, just the opposite was true. On this basis alone, the jury's verdict cannot stand. Chelsea Bailey says, Amber, my ex-Zeus is suing me for an op-ed I wrote. Black Dot Sun Red, thank you for the super sticker. Thank you. We have an asterisk. For the same reasons, Depp failed to meet his burden of proving at common law that Heard designed and intended the alleged implication that he had abused her. Judgment that is plainly wrong or without evidentiary support must be set aside. Additionally, while Depp argued the op-ed reference the day Heard obtained a restraining order by stating she became a public figure 2 years ago, he failed to prove any implication that he abused her was reasonably drawn from the words actually used. There it is again. Okay, so that's the argument that they're making. Not a strong one. It was obviously about him. The jury thought so. The jury concluded so. Moving on. Jadil Medina, thank you for the super sticker. Is that ex-husband? Sorry. My ex-husband is suing me for an op-ed I wrote. Yeah. Exus. What's an exus? Is that kind of like Zeus, but an ex-Zeus? Like I used to be a god? I'm just kidding. All right. Ex-husband. Ex-husband. Thank you. Thank you, chat. This is why, by the way, let me just say this is why I love chat. Because chat is always right. Just so you know, chat, anybody, I know there's some streamers who are like, nah, you know, they'll go against chat. I've learned my lesson. I have learned the hard way. Chat is always right. The streamer may or may not be always right, but chat is always right. So I always default, when I have a problem, like I default to chat and I'm like, if chat says so, then it's true. Don't forget to like this video, comment below, subscribe to the channel. All right, argument number 2 under why Johnny Depp's argument failed. Depp failed to prove by clear and convincing evidence that Heard either knew the alleged implication that he had abused her was false or subjectively entertained serious doubts about its truth. Even if this court concludes that the record contained clear and convincing evidence that Heard knew at the time of the publication that the op-ed communicated to readers the implication that she was asserting that Depp had abused her, the record contains no evidence that she knew or thought it likely that such a statement was false. Depp failed to carry his burden on actual malice for this separate reason. And by the way, pay attention to the fact that we are talking about the case of defamation. At the end of the day, abuse is kind of on the sidelines. Notice how this entire brief is all about defamation, as it should be, unlike the amici, amici, amicus, however you want to pronounce it, how those briefs are all talking about the surrounding circumstances and the abuse and the none of that matters on appeal. We're looking at whether or not there have been any judicial errors made by the Judge Escarati, whether she abused her discretion, whether she misapplied the law, or it should have been done in a different way. This is how a brief is supposed to read. Now, the fact that it's making poor arguments is one thing, but the fact is that it's at least making arguments rather than trying to appeal to emotion as the amici briefs had been doing. This reads at least a little bit smoother, if you noticed. I mean, compare that to my other videos on my channel when I analyzed the other two briefs. I mean, it's like night and day. Night and day, at least in the style as it's written. Claire Nunes says, Amber Heard had to put JD in it somehow to continue to abuse him, I think. Maybe. Karina Deluxe says, AH said, that's why I wrote it on the stand. Case closed. The brief validates it. Absolutely. So far, that's what we have. Jadil Medina says, does she have a chance to recover with this? We haven't finished yet, so save that question for the end. I need to start making videos cheaper than Super Chats, says Nicholas. Hey, you got a handle. Start a channel, bro. Absolutely do it. Absolutely do it. All right, back to the brief. So, Depp failed to carry his burden on actual malice for this separate reason. In this regard, it bears emphasis. There is a significant difference between proof of actual malice and mere proof of falsity. Depp cannot prevail merely by proving that the abuse did not occur. Rather, to establish actual malice by clear and convincing evidence, it was required to offer affirmative evidence that Heard did not believe he had abused her or entertained serious doubts about whether he had done so. There is no such evidence. Depp alleged that the op-ed falsely implied that Heard was a victim of domestic abuse by him, the trial court's identification of alleged defamatory meaning as Mr. Depp abused Ms. Heard, because actual malice is a subjective standard. Whether Heard believed Depp abused her must be judged by her own state of mind. So imagine this is going to run smack dab into an improper instruction, an improper jury instruction the jury should have been instructed more on, because otherwise you can't simply invalidate. I mean, you can invalidate a jury's decision as a matter of law, but it's such a difficult standard. It's such a high burden. It's almost impossible. Judges almost never vacate juries' decisions simply on this. I mean, you need way more. You need way more. Heard testified unequivocally that she believed Depp had abused her physically, verbally, emotionally, and psychologically, and sexually. Don't forget sexually. Why did you not include that here? That's what she alleged. Depp and his expert witness conceded that abuse can take many forms, including verbal, emotional, and psychological. This is really echoing of one of the amicus briefs, or maybe even both of them. And the trial record contains considerable undisputed evidence supporting the proposition that Heard, at the time of publication, believed that Depp had abused her. For example, the record also contains many other examples of disputed evidence of abuse, but the court need not even consider those to appropriately conclude that the trial court should have struck the jury verdict for Depp's failure to prove actual malice. So, this was in the amicus brief. They're duplicating it. Wow. They're actually duplicating it. Depp demanded that Heard cut him with a knife and then threatened to cut himself in her presence when she refused to comply. Depp engaged in violent behavior in Heard's vicinity on multiple occasions, including kicking cabinets and doors, smashing glasses, punching a light fixture, and toppling racks of clothing in her closet and throwing one rack down the staircase. Depp exhibited jealous and controlling behavior towards her, such as accusing her of infidelity, which she absolutely did, as the trial has proven, and promiscuity, including in messages written around the house with his own blood, okay, and forbidding her from acting in movies or having meetings. Depp admitted to head-butting Heard, although he claimed it was unintentional. Depp told Heard on one occasion, "I left last night, honestly, I swear to you, because I just couldn't take the idea of more physical abuse on each other." Importantly, even if the jury could properly have concluded that these undisputed facts, which, by the way, again, undisputed according to whom? The speaker? That's not a good source to cite, but okay, they're citing it. Did not constitute abuse, and a reasonable jury could not have done so. Depp presented no evidence that undercut Heard's testimony that she believed this conduct amounted to abuse. Consequently, Depp failed to meet his burden on the second prong of actual malice, and the court should enter a judgment in Heard's favor for this independent reason. Now let's talk about this argument real quick. This is the jury got it wrong arguments. They didn't even go into jury instructions as I predicted they would. And that's surprising, because to argue the jury got it wrong, you got to remember, again, just like when we talked about in the amicus briefs, the jury is in the best possible position to determine credibility, the veracity of statements, the credibility of witnesses, the truth of what they may or may not be saying, and they read face language, they read body language. They're the best bullshit detectors in the room. So when you have like all these statements and they look really like, imagine we haven't seen the trial for a second, all right? I know it's going to be difficult, but imagine you've never seen the trial. For those of you who have, and those of you who haven't, maybe you already have this in your mind right now. You're going, oh my God, this is horrendous. This is absolutely terrible. This is atrocious. Like, Depp did all these things. Of course she's going to win. But the problem is the Court of Appeals is going to give deference. This is what judges do. On the higher level, on the higher levels, judges give deference to the Court of Appeals. The Court of Appeals gives deference to the jury and the judge and the lawyers, because they were there. They're now analyzing questions of law and questions of law alone. So when you have all this piling on about jury got it wrong, jury got it wrong, jury got it wrong, because Johnny didn't meet his standard, the judges can look at it and go, look, even if there was a little bit, because you don't need a lot, even if Johnny presented a little bit and that was enough for the jury, we're going to go with the jury's verdict. Judges are absolutely, positively terrified of undoing jury's decisions, because imagine what kind of precedent that would set. Imagine what kind of message that would send, that, yeah, you as a jury have decided one way, but you know what? Some panel of 3 judges up there can undo everything you decided if we feel like it, with no justification. Our whole system would collapse. So, Crystal, welcome as a new member. Welcome, welcome. Don't forget to like this video, comment below, subscribe to the channel if you haven't already. I mean, my God. Let's go to argument number 3, shall we? All right. The trial court erred in failing to grant a new trial for multiple reasons. So we covered pre-trial should have been dismissed. That was argument number 1. Argument number 2 was post-trial, the jury's verdict was wrong and should have been vacated. And now argument number 3 is we should have been given a new trial. And here's why. For each of the several independent reasons set forth above, This court should reverse the judgment in favor of Depp and either enter judgment in favor of Heard or dismiss Depp's claims without prejudice. Excuse me. If, however, this court disagrees with all of the foregoing, then, at a minimum, this court should reverse and remand for a new trial, again, for multiple independent reasons. Reason number one. The trial court made numerous evidentiary errors that severely prejudiced Heard at trial. This court reviews a trial court's admission or exclusion of evidence for abuse of discretion. That's the standard for this. The trial court's numerous erroneous evidentiary rulings prevented the jury from receiving evidence highly probative of the truth of the implication Depp alleged the op-ed conveyed and of Heard's lack of actual malice, while also permitting the jury to receive irrelevant and unduly prejudicial evidence used by Depp to attack Heard on purely collateral matters. Each of these evidentiary errors, standing alone, would warrant a new trial and, considered cumulatively, clearly mandate reversal. Remember in the amici briefs, we saw a lot of the uncontroverted evidence, clearly erroneous, clearly this, uncontroverted that. Notice how here it's a lot more minimized. It's a lot more relaxed. The tone is more authoritative than threatening, which I personally, as a judge, like a whole lot more than the threatening tone of the amicus brief. The uncontroverted evidence in the trial clearly and unequivocally states, that no judge wants to be reading that kind of language. Here, we do have it peppered in periodically, but it's not as forceful. It's not as mandatory. It's not as threatening. So I will give credit to the writer that they've softened their tone. And that is a very smart decision in that regard. So tonality here, for the most part, has been non-threatening, you must, because whenever you write you must over and over, you're literally weakening your position. Because the ones who have the strongest argument, they don't have to say you must do anything. You just argue your piece. You make your argument. You put it forward. You don't have to consistently argue, oh, you must do this, and it is unequivocally true, and it will be clearly erroneous and reversible error. They're peppering it in where it belongs, but they're not making a big deal out of it. And I'm not going to lie, I definitely like it way better than when I was reading the amicus briefs. Explaining that two or more individually harmless errors have potential to prejudice defendant to the same extent as a single reversible error if multiple errors so fatally infect trial as to violate fundamental fairness. That's United States versus Basham. Number one, the trial court erred by excluding evidence of Depp's abuse and Heard's state of mind. This is assignment of error number 5. Long before Heard sought a restraining order in 2016, Heard made numerous contemporaneous statements to third parties about Depp's abusive conduct. Instead of permitting the jury to consider this critical evidence, the court excluded it based on an erroneous application of Virginia hearsay law. Virginia hearsay law, or well, I guess Virginia hearsay law was being used, but hearsay is hearsay is hearsay is hearsay. It doesn't matter really where you go. But okay, statements about Depp's abuse made years prior to any potential litigation were essential to the jury's consideration of the fact and Heard's credibility, especially given that Depp made Heard's credibility the linchpin of this case. Well, yeah, because she's the one making the statement. I mean, duh. Welcome as a channel member, Sam Panther. This is wild. Okay. So we excluded what? This is the argument. Numerous contemporaneous statements to third parties about Depp's abusive conduct. So clear hearsay. Clear hearsay. So you can't say that Bobby Joe said this about me because that's hearsay. Or you can't say Bobby Joe told Johnny who told me because that's double hearsay. And you can go further, Bobby Joe told Johnny, told Megan, told me. That's triple hearsay. You can just keep going ad infinitum for infinity. But they're excluding third parties' statements. So what are they? A, Heard's reports of abuse to medical providers plainly were admissible. If you had brought in the doctor, maybe you would have had an easier time. But if you're trying to just admit a piece of paper, not so much. And that sounds like a correct ruling, but I'm just one man. From 2011 to 2016, Heard sought treatment from several medical professionals as the result of her volatile and violent relationship with Depp. A number of these professionals documented Heard's contemporaneous statements about Depp's abuse in medical records. The trial court, however, excluded this evidence as hearsay, which sounds rightful. I mean, what did you just write? A number of these professionals documented her statements. Well, bring the professionals to court, for fuck's sake. Come on. You know the rules of evidence. If you want to get a document admitted, bring the person who wrote it and they can talk about it. And if that is excluded, well, then the court probably thought that the prejudicial effect is outweighing the probative value, which is in the rules of evidence. 403. Hello? 401, 402, and 403. The trial court, however, excluded this evidence as hearsay, which Depp then used as both a shield and a sword. Not only did Depp convince the court to preclude Heard from presenting relevant, admissible evidence to corroborate her claims, there's that powerful language again, but Depp then weaponized that exclusion, arguing to the jury that such evidence did not exist. But that's exactly what you do. That's a lawyer's strategy. That's what you do. Ms. Heard has told you that she has mountains of evidence of abuse. So these mountains, by the way, they don't exist. They only exist in fiction. Because if this evidence really was truly probative, then prejudicial, then the judge would have allowed it in. And if she would have presented the actual doctors and they were relevant and probative rather than prejudicial, they would have come in. So I don't understand this. Crystal says, I didn't go to law school, but I feel like I could have done a better job with this filing. You and many other people, I am sure, as we're going through this. Like, even if she told them to write this, they should have said no. Johnny didn't object to doctor, says Beautifully Damaged. I don't know if that's a part of a statement or the full statement, but all her mountains are molehills. Quite possibly so. So far, it's proving to be true. Oops, sorry. Okay. Virginia's hearsay rule precludes introduction of an out-of-court statement offered to prove the truth of the matter asserted only if the statement does not fall within one of the recognized exceptions to the rule. One exception is for statements made for purposes of medical diagnosis or treatment. Oh, okay. So they're saying they're falling under the hearsay exception of medical diagnosis and treatment. All right, let's see how they do. Medical and psychological records that included victim statements were properly admitted under this hearsay exception. Medical records are admissible under the business records exception to hearsay. The trial court should have admitted Heard's statements to medical providers under this exception. But that's the problem. Heard's statements to medical providers. That is the key. Oh my God, this is huge. Golden nugget number, what are we on? 8, 9? This is huge. This is absolutely critical. For those of you non-lawyers and lawyers alike, listen very, very carefully. You can admit medical records, even for the truth of the matter asserted, if what you're trying to prove is injuries, possibly sometimes alcohol intake, drug intake, like a doctor writing that after observations, it was determined that the patient's elbow was broken or their jaw was broken, their spleen was enlarged, their heart had a murmur, things like that. This is why the business records exception exists. So you don't have to drag in a doctor or a nurse or whoever, medical practitioner, just to say like, yeah, that happened. Yeah, that happened. Yeah, that happened. Because medical records are usually, like a business record. They're kept in the normal, ordinary course of business, and very rarely do people just make stuff up on them. But here's the problem, and this is where the hearsay exception does not allow these things to come in. This is crucial. This is so important. The trial court should have admitted, look at what they're saying. The trial court should have admitted heard statements to medical providers. That is clear hearsay. That is 100% pure, unadulterated hearsay. You can't simply use that to backdoor, oh, you know what? She said this to them, therefore it must be true. Therefore it should be admitted. You can admit, let's say, if she had come in with a broken nose, that would have come in as a fact. A broken nose is not something subject to question. It either happened or it didn't happen. I'll never forget this. In philosophy, one of the earliest, I took ancient philosophy in my college courses, one of the most fascinating classes I have ever taken in my life. And my professor, he said, Dr. Maloney, I'll never forget him, Dr. Maloney, if you're watching this, hey man. Ancient philosophy, the philosophers even went so far as to come up with some basic precepts of reality. And there's this one Greek phrase that I'll never forget. It is estin euk estin. Either a thing is or it is not. There is no in between. Either it exists or it doesn't exist. There's no in between. It is either is or it isn't. Estin euk estin. And this is the same thing that can be applied here. Like if there was a broken nose, it either exists or it doesn't exist. You would be able to show x-rays and bring in doctors, and you can bring in the doctor medical notes and the nurse notes and put on testimony and da-da-da. That would come in. There is zero question. The Judge Escarati would have never not let that in because that would be a clear abuse of discretion and that would be subject to appeal. And Judge Escarati doesn't want to fuck around with the Court of Appeals. No judge ever wants to be overruled. No judge ever wants to be overridden or subject to error. Judges like to make good decisions. So the fact that they did not come in is exactly this language right here. The trial court should have admitted heard statements to medical providers under this exception. But they're statements and they're hearsay. And you can't even bring in an expert to say, well, Ms. Heard told me, objection, hearsay. Well, Ms. Heard came into my office and she said objection, hearsay, and each and every single one of those will be denied, and rightfully so. I cannot believe this is like an intern wrote this. Nicholas says, not even her friends, her leeches, testified about her severely sliced feet, and she met them 2 days after she claimed it happened. Retired Nana says, you mean therapist notes that looks like Amber's handwriting, or those that only write that what Amber told them? Yeah, exactly. That's hearsay. Retired Nana says, no one was a witness to her alleged abuse. Not even her own photos. Okay. The trial court should have admitted, I said that. Okay, separately, the trial court should have admitted Heard's prior statements. Again, statements. Statements are hearsay. She can take the stand and testify about her own behalf. You don't need to introduce, oh my God. These people don't know basic hearsay rules. Separately, the trial court should have admitted Heard's prior statements about DEPP'S abuse as non-hearsay assertions offered to prove Heard's state of mind. It could potentially be an exception, but it usually fails because she can testify about it today, take the stand, and talk about it. You're an available witness. It is black letter law that statements admitted as evidence of an individual's state of mind are not hearsay if they're not more prejudicial than they are probative. You forgot the last part of the rule. A statement that is offered to prove state of mind is not hearsay because it is not offered for its truth. Because of DEPP'S burden to prove actual malice, see above section 2, Heard's subjective state of mind regarding whether abuse occurred was a primary issue in the case. Thus, evidence that she subjectively believed she was a victim of abuse was critical. Finding error where excluded statements were offered to show a state of mind. Affirming admission of statements not offered for truth but to show defendant's state of mind. They're citing some cases here. The trial court also erred when it excluded a May 24th, 2014 text exchange between Heard and her father. Bring in the dad, yo. Bring in the dad. The dad can testify. If the dad didn't want to come in, that's a you problem. Text messages between a party that, the problem is, you see, we have something very, very beautiful in the United States. It's called the Bill of Rights. And the Bill of Rights includes a lot of things. And one of the things that it includes, and I can't remember off the top of my head, is that the Sixth Amendment is the right to cross-examine witnesses. And the right to cross-examine witnesses allows individuals that are accused of either a crime or even non-crimes to put their accusers, or the ones that they're suing, trying to be sued, or getting sued, to the test, to ask them questions. Hey, you said this, now justify it. And that's the problem. You're introducing, this is why hearsay rules are in place, because otherwise somebody will just take the stand and be like, well, like I remember I gave the example earlier, Johnny said to Bobby Joe, said to Megan, said to me, that's hearsay. Bring in Bobby Joe and John and Megan to come testify, and then we'll listen to them. Otherwise, anybody can take the stand, say anything, and now we are supposed to believe you because everybody knows that people lie. The only way to check whether or not they're telling the truth is to see how they speak when they speak. What is their body language like? That's why the courts have these rules. Every single one of these rules has a basis in hundreds of years in basically human study, if you will. The trial court also erred when it excluded the text exchange between Heard and her father, in which Heard reported DEPP'S abusive conduct and asked for help. These messages were offered to show Heard's subjective belief that abuse had occurred, but they also would show that she's saying that abuse had occurred. That's why it's more prejudicial than probative. So it was rightfully excluded, in my opinion. Additionally, the court erred by excluding Heard's statements to Catherine James, in which Heard reported that DEPP was worse than ever. Heard sought the admission of this text to show her state of mind and to impeach James's deposition testimony that DEPP played at trial. The trial court wrongly excluded it. Again, same argument. Here, the trial court improperly prevented the jury from considering several separate instances in which Heard reported DEPP'S abuse to a medical professional. From 2011 to 2014, Heard was treated by clinical psychologist Bonnie Jacobs. So they're going one by one on all the excluded witnesses. Dr. Jacobs's, and by the way, from considering. So did they call these witnesses, or did they just try to offer their statements? Because that's a problem. If you're just trying to offer their statements, it's not admissible. If you try to call them and the judge said, well, they're not going to testify, that's the prejudicial versus probative argument. Is it more prejudicial than probative? And if it's just about statements, well, then it's hearsay. So they're not even going to be able to testify. They're literally trying to erode the whole doctrine of what hearsay is. I'm flabbergasted. Maybe not to you all, but this is definitely golden nugget number 10. Trying to completely unravel what hearsay is for purposes of winning. Please, come on. This is pure hearsay. If they're just going to testify about what they said to me, you can go to it. Listen, when you're building a case, you can literally go to a therapist and be like, all right, this is what I'm going to tell them, and this is how I'm going to paint it. And then you can craft ahead of time an argument for that. This is not how the courts function. Trying to erode the doctrine of hearsay is not going to serve any purpose for your appeal. So the contemporaneous medical records show Heard reportedly reported Depp's abuse. Hearsay. For example, in August 2012, Heard reported Depp was in a rage, accused her. Okay, so they're trying to show the judges what she would have said. Was in a rage, accused her of cheating, threw a glass by her head. In September 2012, Heard reported Depp was violent and ripped her nightgown, threw her on the bed, tried to have sex but couldn't get erection, became more angry. 3, on November 15th, Heard reported sometimes Johnny becomes verbally sexually abusive after spending time with father. From 2014 to 2016, Heard was treated by psychologist Connell Cowan. Dr. Cowan's records reflect that in December 2015, Heard reported that Depp was physically abusive and that he started the physicality, pushed her down. From 2014 to 2016, Heard sought treatment from nurse Erin Falati for injuries caused by Depp. Falati's notes reflect that on December 16, 2015, Heard reported that Depp headbutted her, and on May 21st, 2016, Heard reported that Depp hit her in the face. 2015-2016, Heard and Depp saw Laurel Anderson, a clinical psychologist who was treating them. During therapy sessions, Heard reported that Depp slapped her, hit her in the head, pulled her hair, kicked her in the leg, causing bruises. In 2015 and 16, Amy Banks, a clinical psychologist, treated Heard and Depp. In a joint session, Heard discussed Depp's violence, which she did not contradict. This statement should have been admitted for the independent reason that it constitutes Depp's admission by silence. And there's case law on it. A declaration in the presence of a party to a cause becomes evidence as something that the party, on hearing such a statement, did not deny its truth. For if he is silent when he ought to have denied, there is a presumption of acquiescence. And again, the problem with every single one of these that I just read, for those of you who are not familiar with the American judicial system, is these are all statements made to, there's actually another exception. The patient-therapist confidentiality, not really applicable here. I don't think that was ruled on by the court. But even if you're trying to overcome that this way, it's just basic hearsay. This is why we don't allow people to come in and say that they said this to me, or here's a piece of paper that shows this is what they said to me. Even if you discard the whole idea, let's say these are true notes. They could have been stated as a lie by the speaker. And just because they're written down by a therapist doesn't automatically, magically make them true. That's not how the law works. The law is specifically designed to prohibit hearsay from coming in, from tainting the jury's minds. The judge simply wanted people via deposition remote deposition, remote testimony, or testimony in the courtroom, and nothing more for the most part. They're trying to undo the whole doctrine of what hearsay means. Whew. These statements, which were made long before, and this is their counter argument to what I just said, long before Heard would have had any motive to fabricate allegations of abuse, each should have been admitted as statements made for the purpose of obtaining medical treatment for both emotional distress and physical injuries, as well as statements showing Heard's state of mind. Dr. Kipper and Debbie Lloyd, Heard's and Depp's physician and nurse, also wrongfully were precluded from testifying that Depp worked himself up into a rage and tried to fight Heard while Depp was going through substance abuse withdrawal in August of 2014. Heard also reported to Dr. Kipper that Depp pushed her. Again, it's all hearsay that she admitted, reported to Kipper that Depp did this. Statements. Nothing but statements. Hearsay. So I understand the court's ruling. And now they're trying to undo it on the appellate level. Moreover, each of the statements about Depp's abuse, whether made to medical professionals, friends, or family, also should have been admitted for the independent reason that they are prior consistent statements. Interesting. A prior statement that is consistent with the hearing testimony of the witness is admissible for purpose of rehabilitating the witness's credibility. Ordinarily, proof of statements made by a witness out of court cannot be received to corroborate his testimony, but such statements may be admitted where the credibility of the witness has been assailed on the ground that his story is a recent fabrication or that he has some motive for testifying falsely. Again, that would be true, but for the prejudicial value and how it would taint the jury's minds. That's why it was properly excluded, in my opinion. Once Depp attacked Heard's credibility and accused her of fabricating her allegations of abuse, the trial court should have permitted her to introduce these prior consistent statements, and I respectfully disagree. If not reversed, the trial court's exclusion of contemporaneous reports of domestic abuse to medical professionals will make it more difficult for other abuse victims to prove allegations of abuse and likely deter them from coming forward. Now, this is just a one little tiny preview that they have included there. If you notice, the amicus briefs went deep into this. They had entire sections about it. Meanwhile, they just included one quick little paragraph just to mention it. By the way, it would deter, just a fair reminder, blah, 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 you know. Crazy. Absolutely crazy. The trial court wrongly excluded, this is part 2 of this argument, wrongly excluded corroborating testimony of Heard's allegations. The court improperly excluded a text exchange in which Depp's agent, his personal assistant Steve Deuters, corroborated Heard's allegations of abuse on a flight from Boston to Los Angeles. A statement by the party's agent or employee made during the term of the agency or employment concerning a matter within the scope of such agency or employment is an exception to the hearsay rule. Exclusion of statement made by employee concerning a matter within the scope of his employment was reversible error. On May 25th, 2014, Deuters sent a text message to Heard stating, "When I told Depp he kicked you, he cried." Deuters sent Heard this message after Depp told Deuters to smooth whatever issue existed with Heard by texting Heard and telling her whatever she needs to hear. The trial court should have admitted this evidence as a party opponent admission because Deuters was an agent of Depp, and Depp specifically instructed Deuters to communicate with Heard regarding the altercation. Given Depp's attacks on Heard's credibility, this text message was critically important. Again, we're falling back onto the hearsay. I disagree that it should have been included. I agree with the court. The trial court improperly excluded the UK judgment. This is the weakest of them all. Prior to trial, Heard opposed Depp's motion in limine to exclude the UK judgment. And during trial, Heard sought to admit the judgment after Depp opened the door to the evidence on numerous occasions. I had waited for my opportunity to address the charges, and so today is my first opportunity that I've been able to speak about this case in full for the first time. While the trial court allowed references to the UK proceeding, it precluded the jury from learning about the outcome. Admitting the UK judgment would not have been fairly prejudicial to Depp, but its exclusion unfairly prejudiced Heard in at least two ways. First, the court's decision to allow Depp to refer to the UK proceeding without explaining the outcome left the jury with a mistaken impression that the outcome of the trial was favorable to Depp. That's a stretch. That's definitely a leap of logic, but okay. When, in fact, the UK court found that Depp had abused Amber on at least 12 different occasions. Depp promoted his misperception throughout the trial. While testifying, the court permitted Depp to read into the record the title of an article. Johnny Depp was the victim of abuser Amber Heard, London's High Court told. Similarly, Depp's damages expert testified that Depp brought the UK proceeding to clear his name, which served to mislead the jury about the outcome of that proceeding. Secondly, as more fully described in section 3.5 below, the Sun article that precipitated the UK proceeding, Depp's decision to file the UK lawsuit, the trial, and significant media attention, and the UK judgment finding that Depp had in fact abused Heard undoubtedly negatively impacted Depp's reputation. Nonetheless, Heard was precluded from presenting the jury with this highly relevant evidence regarding damages. Evidence of poor reputation is relevant to mitigate damages because of the prejudicial impact to Heard, and given Depp's false and misleading testimony, the trial court erred by excluding evidence of the UK judgment. Once again, we're falling back on this whole prejudicial versus probative problem. Judge Ascarati made it clear from the beginning that Johnny did not get a fair shake in the UK because of the different rules of evidence, different rules of conduct, different standard, and different defendants. So she said, you have an opportunity, Johnny Depp, to litigate your case here in the United States, and I'm going to give you the platform. Do your thing. Win, lose, whatever. And the fact that it was allowed, now her lawyers are like, look, it should not have been allowed. And if it wasn't even allowed, the jury should have heard about this judgment that happened back there, which is complete nonsense. That was the whole point. That was the whole purpose of this trial in the first place. Nicholas says, the Virginia Appellate Court, please ignore the Declaration of Independence. Yeah, exactly. Django the Dane and Mom. What a beautiful doggo. Thank you, Larry, for taking the time to go through this and being so thorough and educate us with the details. You're my number one. Aw, you're my number one too. Thank you. Crazy. Absolutely crazy. Number 3, the trial court erred when it precluded Depp from answering a question about the truth of one of the allegedly defamatory statements. Depp alleged that Heard defamed him by falsely writing in the op-ed, I became a public figure representing domestic abuse. I want to make sure I don't lose my voice. Has it seriously been 3.5 hours? You guys, it did not feel like it. I feel like I just got started. But for my voice, I legitimately feel like I just started. This is so fascinating. If I haven't told you, if you don't know me, I legitimately nerd out on this shit. This is like stamina for me. This is like mana from heaven. Don't forget to like this video. Like this video, comment below, subscribe to the channel. Okay. Trial court erred when it precluded Depp from answering questions about the truth of the allegedly defamatory statements. Depp alleged that Heard defamed him by falsely writing in the op-ed, "I became a public figure representing domestic abuse." On cross-examination, Heard's counsel sought to ask Depp whether that specific statement was accurate. Despite the fact that Depp was required to prove the falsity of the statement as an essential element of the claim, which is an essential element, that's why it's a legal conclusion, the trial court precluded him from answering the question on the grounds that it was called for a legal conclusion. That was an abuse of discretion. That's their argument. The Rule 2:704A allows testimony on an ultimate issue unless the testimony calls for an opinion that constitutes a conclusion of law. Whether a statement of fact is true or false is not a conclusion of law. Whether an allegedly defamatory statement is false ordinarily presents a factual question to be resolved by a jury. Heard clearly was prejudiced by this error. Depp's testimony that the statement was accurate, i.e. not false, would have required entry of judgment for Heard on that particular claim. Granting summary judgment to defend a newspaper because plaintiff failed to carry his burden of proving the material falsity of any of these statements is a matter of law. The plaintiff in a defamation action has the burden of proving that the statement is false. The trial court erroneously admitted irrelevant and prejudicial evidence. In at least 2 instances, the trial court admitted irrelevant and unduly prejudicial evidence that had nothing to do with the case, but allowed Depp to attack Heard's character. Evidence that is not relevant is not admissible. Evidence must relate and be confined to matters in issue, and it must tend to prove or disprove these matters or be pertinent to them. Evidence of collateral facts and those incapable of affording any reasonable presumption or inference cannot be accepted in evidence. So just these last 2 real quick, if you notice, this one I kind of skimmed over just because it's so basic, it's so simple, it's so direct. He should have answered the question. He was not allowed to because it called for a legal conclusion. That was wrong. And now here, we had some additionally irrelevant prejudicial evidence. Let's see what it is. In addition, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice or its likelihood of confusing or misleading the trier of fact. Evidence regarding specific instances of conduct of a witness, when allowed, normally is limited to cross-examination for impeachment purposes. Extrinsic evidence related to those acts is not allowed. The reason underpinning this rule is that the admission of evidence of specific acts and the rebuttal evidence which would follow injects collateral issues into the case which would divert the jury's attention from the real issue. Noting that the collateral issues rule precludes a party from calling witnesses to impeach a witness's character. So where are they? And I think they have at least 2 here. The trial court committed reversible error when it admitted extrinsic evidence of Heard's pledge to donate money to charity. This is the whole pledge versus donate, if you remember. I'm sure you do. The trial court committed reversible error when it admitted irrelevant and unfairly prejudicial evidence related to a purely collateral issue, Heard's pledge to donate proceeds of her divorce settlements to charity in 2016. While a party has significant flexibility to cross-examine a witness and impeach her, the Virginia rules of evidence limit a party's ability to introduce extrinsic evidence to attack a witness's credibility. See rule such and such. Specific instances of conduct of a witness may not be used to attack or support credibility, and specific instances of the conduct of a witness may not be proved by intrinsic evidence. Let me just pause right here for just a second. tell you guys something. Notice how this brief has consistently been going, literally bouncing from the left and to the right, and then they're arguing this, and then they're arguing that, and then they want to argue this point and argue that point and argue this point. Does that remind you of anything? Of any particular statement maybe that comes to mind, of some, not, I wouldn't call it jargon, something about throwing things at the wall and seeing what sticks? Maybe. They're literally throwing the kitchen sink. They're throwing away the baby with the bathwater. They're throwing everything on the wall just to see what will stink, what will stick, what will stink. Freudian slip there. This is impressive. I'm not going to lie. And it's not impressive for the reasons you think I'm saying. It's impressive in the sense that it is so devoid of a central theme. They're literally like, all right, here are all the errors. Boom. You deal with it. It really doesn't have any like real coherency. It's not cogent. They're just like, here's this, here's that, boom, 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 boom. And now you decide, Court of Appeals. It's not a good strategy. You want to take like three main arguments usually, and they do have three on its face. Remember, we started with it where it was like 1, 2, 3, but they're underlying, under the umbrella, they have like 50 of them that are just like, okay, and then there's this, and then there's that, and then there's this, and then there's that, and don't forget about this, and don't forget about that, and then there's this, and then there's that, and then there's this, and then there's that, and then don't forget about this, and don't forget about that, and then there's this, and then there's that, and then don't forget, like literally, it's that's their whole brief so far. Larry's not impressed. But hey, when you have shit, you write it out. It's just the way it works. The trial court improperly permitted Depp to introduce extrinsic evidence about Heard's pledge to donate $7 million to the ACLU and the Children's Hospital to attack her character and integrity, which she, I think, was quite deserved, but okay, because her integrity was in question. The pledge, which was announced 2 years prior to the publication of the op-ed, was not relevant to Depp's defamation claims and was unduly prejudicial. That's the argument. Indeed, Depp not only used this evidence during cross-examination of Heard, but he introduced collateral evidence, including witness testimony from representatives of the ACLU and Children's Hospital about the pledge, for only one thing: to prejudice the jury against Heard and paint her as a liar who only wanted public praise. Nugget number 11. They accidentally spoke the truth once again about Amber. To paint her as a liar who only wanted public praise. They accidentally spoke the truth. It's like having an 8-year-old tell you about the dream they had last night, says Julio. Okay. And that's because you wanted the entire world to think that you were donating every penny of the $7 million divorce settlement as soon as you received it from Mr. Depp. Isn't that right? So as of today, you can hear Camille's voice. I'm trying to like. So as of today, you have not donated paid $7 million of your divorce settlement to charity, right? And that's because you did want something. You wanted Mr. Depp's money. Lies. This is Ms. Heard's narrative. Lies upon lies. The testimony created a mini trial on what Heard donated, what her intent was, and whether she intends to fulfill the remaining pledge. Again, none of this related to the op-ed or whether Depp abused Heard, but it did relate to the defamation in her character. So there are also some exceptions to the rule, and the judge ruled on them, and I think she ruled correctly. But we will see what the Court of Appeals says. Excluding evidence of prior donation as evidence could have an extremely unfair prejudicial effect on the defendant. B, the trial court committed reversible error when it admitted extrinsic evidence of Heard's alleged domestic abuse more than a decade earlier. The trial court also allowed improper impeachment of Heard when, in rebuttal, Depp presented testimony of Beverly Leonard, a police officer purportedly present when Heard was arrested in 2009. The court clearly erred when it admitted this evidence on an entirely collateral issue. During cross-examination, Depp asked Heard about domestic abuse he alleged she engaged in during a prior relationship. Heard denied the allegation. That should have been the end of it. However, the court permitted Depp to call Leonard, a former police officer, to testify that in 2009 she saw Heard acting aggressively towards her then partner, grabbing her partner and pulling her partner's necklace from her neck. Permitting extrinsic evidence of an incident that occurred 9 years prior to the publication of the op-ed violated rule such and such and allowed Depp to paint Heard as a bad person, holding that lower court committed reversible error when it allowed extrinsic evidence on collateral issue to impeach defendant's credibility. The court's decision to admit Leonard's testimony regarding an incident that occurred 9 years before the publication of the op-ed served no legitimate purpose. So that's the argument that they're making. The trial court's evidentiary rulings encourage the jury to award damages that are unrelated to the op-ed. The trial court's erroneous evidentiary rulings also left the jury without crucial evidence regarding Depp's reputation and therefore prevented the jury from accurately assessing any harm proximately caused by the op-ed. First, the trial court erroneously excluded as hearsay articles relevant to Depp's reputation prior to the publication of the op-ed. Again, remember, that was the tabloids. The tabloids, when Rottenborn read the titles of the tabloids, but they wanted to introduce the entire articles. The entire articles. And the judge said no, because it's hearsay. And it's fucking tabloids. It's true. The articles, however, were not hearsay, as Heard sought to admit them not for the truth of the matter asserted, which is a cute, backdoor argument, which doesn't work, but to show the state of Depp's public reputation prior to the publication of the op-ed. Evidence of prior contemporaneous publication is admissible to mitigate contemporary damages. Second, the trial court excluded relevant evidence related to the UK proceeding, including the Sun article and the UK judgment. At a minimum, the jury should have been permitted to determine whether it was appropriate to apportion any claimed reputational damages between the op-ed and the Sun article. Upholding admission of prior contemporaneous articles to mitigate damages because the defendant could not be held liable for injuries that it did not cause. Indeed, the trial court agreed that this evidence was relevant, but it nevertheless precluded Heard from introducing the Sun article, the UK judgment, and published media reports regarding the UK proceeding. The headlines of these articles included, and this is all the hearsay stuff, but not limited to. Johnny Depp friends and family seriously concerned about him. Here's why. Johnny Depp, a star in crisis, and the insane story of his missing millions. This is all the media just writing all this stuff, and it's all rightfully hearsay, not admissible. Doesn't matter what you're trying to introduce it for, it's going to taint the jury's mind. And the judge excluded it. Johnny Depp reportedly drank heavily and was constantly late on the new Pirates movie set. Johnny Depp's financial woes might sink the next Pirates of the Caribbean. Where did it all go wrong for Johnny Depp? After a string of flops and a ton of bad press, Johnny Depp's star power looks as wobbly as Jack Sparrow on a plank. Johnny Depp allegedly showed up drunk to movie premiere, reports say. The trouble with Johnny Depp, multi-million-dollar lawsuit, a haze of booze and hash, a marriage gone very wrong, and a lifestyle he can't afford. Inside the trials of Johnny Depp. Vodka for breakfast, 72-hour drug binges, and spending sprees that beggar belief. Alison Boshoff reveals why Hollywood's reeling over what's being called Johnny Depp's career unliving himself note. And how can J.K. Rowling be genuinely happy casting wife beater Johnny Depp in the new Fantastic Beasts film? All hearsay. Similarly, by precluding Heard from admitting the UK judgment, the jury was left with a false impression about Depp's reputation because of the UK proceeding and the significant corresponding media attention. By November 2nd, 2020, the world already saw him as a domestic abuser. Nonetheless, the trial court kept that critical information from the jury. Thank you, Lisa. She says, but the pledge and donate issue was huge. In fact, they relied so much on the UK trial, how can they dismiss it? Judge Nichols believed her and said she was clearly not a gold digger. It influenced his ultimate decision. There you have it. Thank you for that, Lisa. Given Depp's claim that the op-ed caused him significant reputational harm, it was critical that the jury hear relevant information regarding his baseline reputation. We have said, in this one case here in Virginia, we have said that one with an unblemished reputation is entitled to more damages when subjected to defamatory statement than one whose reputation is a little hurt by the statement. The effect of bad reputation is to reduce the damage inflicted. The only problem is, again, reputation is definitely always in question, but you can't use tabloids to show reputation. You have to bring in witnesses who will testify. You can't just throw stuff at the wall. Again, they love trying this strategy. Let's throw stuff at the wall and see what happens. It doesn't work. Thus, while the jury was allowed to hear testimony of Depp's harm as far back as 2016, the jury was not able to fully assess the reputational harm unrelated to Heard's op-ed or the impact of a judgment that found Depp to have committed acts of domestic abuse, including sexual violence. Oh, there we go. Finally, on page 46, for the first time in this entire brief, they're like, oh yeah, by the way, we totally forgot about this, didn't we? The sexual violence. Yeah. Write it in. Good idea. Write it in. Don't forget about it. Isn't that going to be, like, when it's true, isn't it going to be your lead? How is this on page 46 for the first fucking time? Will somebody please explain it to me? They're literally using it as a, oh, by the way, we kind of forgot to mention there was we said psychological, physical, and mental, and there was also sexual violence. Well, anyway, moving on to my next argument. Like, really? I just don't get it. As discussed more fully below, infra section 3E, the impact of this error was compounded by the separate error in permitting Depp to claim damages based on conduct unrelated to the op-ed, including the 2016 restraining order. All of this resulted in an indefensible $10 million compensatory damage verdict and $5 million punitive damage verdict, a verdict that demands reversal. Okay. B, the trial court erred by not dismissing the claim based on the headline for the web version of the op-ed because the evidence established that Heard did not publish it. Although she admitted to republishing it. Okay. The trial court erred by not striking evidence or setting aside the jury's verdict based on DEPP'S failure to prove a required element of one of his claims, that Heard published the challenged headline of the online version of the op-ed. I spoke up against sexual violence and faced our culture's wrath. That has to change. Publication by the defendant is an essential element of a claim for defamation. In reviewing a trial court's denial of a motion to strike evidence or set aside a jury verdict, this court considers whether the evidence presented, taken in the light most favorable to the plaintiff, was sufficient to support the jury verdict. The trial court also denied Heard's motion in limine to exclude and redact the headline. The undisputed evidence established that the Washington Post drafted and posted the headline without Heard's knowledge. What? Golden nugget number 11. Now they're starting to contradict themselves in their own brief. Welcome, Aaron Morgan, as a member. How is this in one brief? The undisputed evidence established that the Washington Post drafted and posted the headline without her knowledge after she said, I wrote the op-ed. Wow. This is that's what I'm starting to think. Prasanta Buyan, you literally took the words out of my mouth. I was thinking just that. It feels like this brief was written by people who have not watched the trial, have not followed the evidence. And number two, it's written by multiple people who did not coordinate together. And there's a third one. After it was written by a lot of people who did not coordinate together and did not watch the trial, it was proofread by somebody who did not know what they were doing, who was not ever done proofreading, or it was never proofread at all and just proofread in chunks by the individual arms. It's like an octopus. Imagine, this is what it feels like. It's like an octopus wrote this, right? We have 8 arms, and they're all writing. Okay, you're going to write pages 1 through 6, and you're going to write pages 7 through 12, and you're going to write pages 13 through 15, and you're going to write page. And then they're all like, all right, you guys ready? And let's go. And then they kind of like mesh it together. That's the way I see it, because it doesn't make any sense how else you would do that. The undisputed evidence, and you're just citing it to the record. All you have to do to negate that statement is in your response, Camille and Ben, literally just write, and this is why I wrote the op-ed, quote unquote, cite to the record. I mean, I don't need to tell them to do that. They already know. That's like the easiest response to that statement right there. I can't believe this actually has been submitted to the court. All right, let's keep going. Heard testified that she did not notice the headline when she tweeted a link to the op-ed. Please. Please. Wow. Ems Maurice says, you're an absolute legend for trawling through this, Larry. Massive respect, brother. Oh, gosh. Thank you. I'm trying. This is a disaster. This is an absolute disaster. She didn't notice? Oopsie. Because that's what you normally do, right? On Twitter, you just reshare things to your hundreds of thousands of followers or whatever. Click, oops. I didn't know what was in it. I didn't know it was a link. Why wasn't the tape, says Bev's Fry Bread Wisdom, where AH recorded confessed to cutting Johnny's finger off and hitting him, not allowed in the UK or the US courts? If a murder was recorded, it would be allowed in evidence. That's a great question. And it was probably either a strategic decision or there was a hearsay rule or some other rule that prevented it from coming in. Nicholas says, between 2008 2016, I wrote, or Ghost wrote, roughly 60 opinion pieces. My eyes are starting to get a little cross-eyed. You'll have to excuse me. Roughly 60 opinion pieces. Not one was I not consulted about the presentation or headers, paper or online. Not in one was I not consulted about the presentation. Exactly. That's the proper way of doing things. And right now we're reading the improper way of doing things. Claire Noon says, when AH was last on the stand and their closing statements, they left out the sexual violence. Oh, so they kind of dropped that, huh? When they realized it's not working. Okay. Thus, there is no evidence that Heard published the headline. I'm done with that. Jesus. Indeed, Depp effectively conceded this, his theory being that Heard republished the headline when she later tweeted a hyperlink to the op-ed. Whoop-de-doo. But courts consistently have held that providing a hyperlink does not constitute republication, even in a tweet that favorably references the article, unless you wrote the op-ed. Fourth, a mere hyperlink, without more cannot constitute republication. Publishing a favorable reference with a link on the internet does not republish the article unless you wrote it. There is simply no evidence that Heard published or republished the article, which she did both because she wrote it. Run-of-the-mill hyperlinks typically demonstrate neither the intent nor the ability or to garner a wider audience than the initial iteration of the online statement could reach. And by the way, when you republish, you are reaching a new audience, so that argument also fails on its face, but okay. The majority of courts that have squarely addressed whether a hyperlink constitutes republication have concluded that it does not. A tweet that merely refers to the article hyperlink is not a republication. This was probably what she consulted her lawyers on, by the way. Before she published it, she was like, well, what can we do to avoid liability? And one of the things was like, well, can I retweet it? And they're like, yeah, it's not, republication is not, you're not admitting, just don't write anything extra and you'll be fine. And she's like, okay, cool, click, and here we are. Judge Escarati determined by quote tweeting it was her republishing, says Julie O. It had more than just the link, OMFG, I hate these people. I mean, they're trying, they're trying, you know, it is what it is. They're trying. There is simply no evidence that she published or republished. Thus, the trial court erred in two ways. First, the trial court's refusal to exclude the headline from evidence led to the introduction of irrelevant and prejudicial evidence and arguments about whether Depp had committed sexual violence against Heard, and a phrase that does not appear in the challenged portions of the op-ed authored by her. Authored by Heard? What? Did this just happen again? Is this number 12? Golden Nugget number 12? Or am I just going to literally die in contradiction heaven tonight? What did I just read? The trial, the first prejudicial evidence and arguments about whether Deborah committed sexual violence against Heard, a phrase that does not appear in the challenged portions of the op-ed authored by Heard. Zinnia, I think you could have done a better job. I am about to cry. They just spent like 50 pages trying to defend the fact, no, she didn't write it. No, she didn't do it. No, she didn't write 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 it. And now they're like, oh, yeah, but she wrote it. What are you doing? This is your fucking brief. This is your chance. This is your, as Eminem would say, your one shot, one opportunity. You can't spend 50 pages saying I didn't write it and then say, oh, and she wrote it. Thank you, Boho House. You can't make this stuff up. That's not a golden nugget. I'm sorry, I take it back. That's diamond nugget number 2. So that's diamond nugget. That's fucking platinum. That's a diamond necklace platinum nugget of material that has been found on the moon. Some moon rock. That's a moon rock nugget. That's like an asteroid rock nugget. This is what is the most precious metal that you cannot find on Earth type nugget. That's what it is. Did we just admit that she did write it after arguing for 48 pages that she didn't write it? A phrase that does not appear in the challenged portions of the op-ed authored by Heard. A phrase that does not appear in the challenged portions of the op-ed authored by Heard. All right, let's keep going. As opposed to other forms of abuse, the word that Heard did use, thus infecting the jury's verdict as a whole. Second, because the jury awarded to Depp $10.35 million for all three challenge statements together. There is no way to know how much of the award is attributable to the headline that Heard did not publish. We don't care. The only remedy for these errors is to grant a new trial on both liability and damages, but at a minimum, this second error requires a new trial on damages. Yeah. You just unraveled your entire fucking argument. I can't take you seriously anymore. The trial court improperly instructed, the trial court improperly instructed the jury on actual malice. The trial court refused Heard's proposed jury instruction CC, which set forth the communicative intent prong of actual malice that Depp was required to prove by clear and convincing evidence for his defamation by implication claims. As a result, the instructions given to the jury on actual malice were missing this crucial component of the standard, and a new trial on liability, therefore, is required. A trial court gave two jury instructions defining actual malice. Instruction AA addressed only the falsity prong of actual malice. Instruction BB correctly clarified that actual malice is not established by ill will or hatred. And Heard's proposed jury instruction CC, which the court refused, addressed the communicative intent prong of actual malice that must be established when, as here, the claim is defamation by implication. That is, the jury should have been instructed that it also must find by clear and convincing evidence that Ms. Heard either intended to communicate the defamatory implication or knew of the defamatory implication and was reckless in regard to it. And like I said, this is probably, believe it or not, and I don't know why it's buried in the last 5% of the brief, is probably their strongest argument. Is Rocket Man paying them behind her back? I don't know, Lisa. Is Elon Musk involved? There's rumor that the baby that she's got is his baby. I don't know. Objection, speculation. So I think this literally is their strongest argument. I don't know why it's buried on page 50. When considering whether a jury instruction was properly refused, the evidence is viewed in the light most favorable to the proponent of the instruction. If a proffered instruction finds any support in credible evidence, its refusal is reversible error. As explained above, Section 2A, Depp presented no evidence that Heard either intended to communicate through the op-ed that he had engaged in domestic abuse or knew of the defamatory meaning and was reckless in regard to it. To the contrary, the evidence showed that Heard made significant efforts to eliminate any such innuendo. The trial court's improper refusal of proposed jury instruction CC requires reversal of the judgment and a remand for a new trial. And again, I stand by it. I think that is absolutely their strongest argument. I still think it's weak, but it's definitely their strongest of the weak arguments. Julio says, yeah, but then Elaine tried putting it in closing and got objection because she misstated the law. There you go. The jury verdicts are inherently and irreconcilably inconsistent. This is another one that I think is fairly interesting to look at. I don't know how much muster the judges are going to put on it. And again, why is that on page 50 and not in the beginning? But that's just me. I would have put these in the front and center and talked about them way more, but it's too late for that. Jury verdicts that are irreconcilably inconsistent cannot stand. If there's no reasonable way to harmonize the verdicts based on the evidence presented at trial, a new trial should be granted. To reach, again, and this goes to show the whole alphabet soup, throw everything on the wall, see what sticks argument. They don't even know what they're doing. They don't even know what they're after. They don't even know how, where their strongest potential for victory potentially lies. I mean, this is bonkers. To reach the verdict against Heard on Depp's claims, the jury necessarily found that Heard had not been abused by Depp and that she knowingly lied in stating that he had abused her. Yet at the same time, to reach the verdict in favor of Heard on one of her own defamation claims against Depp, the jury necessarily found that Heard did not lie about being a victim of domestic abuse at the hands of Depp. Specifically, during the May 21st, 2016 incident preceding the restraining order, as Depp argued prior to trial. This case involves two essentially mirror image defamation claims asserted against the only two people who truly know whether the statements at issue are true or false. If Mr. Depp did not abuse Ms. Heard, she indisputably knows her claim that he did is false. And Mr. Depp did abuse Ms. Heard during their brief marriage. He knows that Mr. Waldman's statements calling Ms. Heard a liar are false. Thus, the trial court erred in declining to set aside the jury's verdict against Heard on the ground that it is inherently and irreconcilably inconsistent with the verdict against Depp. The judgment against Heard should be reversed and the case remanded for a new trial on Depp's claims for this reason. That's the argument. The jury's damages award is excessive. The Virginia Supreme Court has instructed that courts have a duty to correct a verdict that plainly appears to be unfair and would result in a miscarriage of justice. Setting aside a jury verdict is necessary when the award is so excessive that it shocks the conscience, creating the impression that the jury was influenced by passion, corruption, or prejudice, when the jury has misconceived or misunderstood the facts or the law, or when the award is so out of proportion to the injuries suffered as to suggest that it is not the product of a fair and impartial decision. If the size of the verdict bears no reasonable relation to the damages disclosed by the evidence, it is manifestly unfair. A trial court's denial of a motion to set aside the verdict as excessive is subject to review for abuse of discretion. Depp's damages are limited to the narrow period between the publication of the op-ed and the issuance of the UK judgment, December 18, 2018 to November 2nd, 2020. I don't know if that is an accurate statement, but they're making it. Depp represented he would not seek damages after November 2nd. So if he said that, then that might be true. Depp failed to prove any pecuniary damages resulting from the op-ed during that time, which I think that's false. And he did not seek emotional distress damages, which he doesn't need to. It's a strategic decision, leaving reputational harm as his only possible source of damages. For a celebrity, that can be pretty huge. Ian Kinzel says, won't happen, but I'd love if the appellate court was like, okay, you're right. These are contradictory. We're overturning the verdict on Waldman. It might. I mean, we're not even talking about this Johnny's appeal right now, but we will be again once Amber replies to it on Friday. First, there's no evidence upon which the jury could rely to determine that Depp suffered any, or sorry, did I skip something? The jury's verdict, of $10 million in compensatory damages is grossly disproportionate to any reputational harm the op-ed could have caused during that small window. First, there is no evidence upon which the jury could rely to determine that Depp suffered any pecuniary loss because of the op-ed, and that was shown through testimony during the trial, I believe. Depp principally claimed that he lost the role in Pirates of the Caribbean 6, Pirates 6, because of the op-ed, but the trial court does not support such a conclusion. The trial record, does not support such a conclusion. As an initial matter, Depp failed to establish that he actually had the opportunity to act in Pirates 6. And then lost it. He did not have a written contract for the film. Even before the op-ed was published, the media reported that Depp would not be in the film. Bev's Fry says, the award was excessive. She asked for twice as much. Yeah, exactly. But it's not about how much you ask, it's about how much you get. But good point. Even before the op-ed was published, the media reported that Depp would not be in the film. And his agent testified that Disney was non-committal about giving Depp the role. At any rate, Depp testified that he would not have agreed to play a role in Pirates 6 even for $300 million in a million alpacas. Depp also did not prove that he lost the opportunity to appear in Pirates 6 because of the op-ed. Disney's corporate representative testified that no decision maker within the company had ever said they would not cast Depp because of the op-ed, nor did Depp present any evidence that he lost other opportunities because of the op-ed. For example, Depp still has an endorsement deal with Dior, which began in 2015. Oh, so they're bringing Sauvage in there. And I think it's interesting because they're like, well, look, why they're making this argument is like, even if we lose, they're like, even if we lose the appeal, maybe they'll at least overturn the monetary judgment. They'll say, look, this is excessive and here's why. This is like a fallback to the fallback argument. If we lose on everything else, then we at least maybe can get the monetary damages lowered for our good little Amber. That's when all you have remaining is that's the kind of argument that you make. You have nothing left. This is why this is towards the end. Given that the jury could not have awarded Depp damages for any pecuniary losses based on the evidence at trial, and Depp never sought emotional distress damages, the only damages the jury could possibly have awarded were for general reputational harm. Even for non-pecuniary damages, however, a jury must still award damages that resulted only from the defendant's wrongdoing and not from other causes. The trial court improperly admitted evidence that encouraged the jury to award damages for conduct unrelated to Heard's op-ed, specifically evidence of reputational harm stemming from Heard's 2016 TRO. Depp's trial theme was a plea for the jury, through its verdict, to rectify the damage Depp suffered as a result of the restraining order. On May 27, 2016, Ms. Heard walked into a courthouse in Los Angeles, California, to get a no-notice ex parte restraining order against Mr. Depp, and in doing so ruined his life by falsely telling the world that she was a survivor of domestic abuse at the hands of Mr. Depp. Today, on May 27, 2022, exactly 6 years later, we ask you to give Mr. Depp his life back by telling the world that Mr. Depp is not the abuser as Ms. Heard said he is, and hold Ms. Heard accountable for her lies. This sounds like the closing argument of Camille Vasquez. These sentiments permeated the entire trial. According to Depp, when Heard obtained the restraining order, he lost nothing less than everything. He explained, when the allegations were made, when the allegations were rapidly circling the globe telling people that I was a drunken, cocaine-fueled menace who beat women, suddenly, in my 50s, it's over. You know, you're done. In fact, Depp's testimony began with an explanation of why he brought this case. About 6 years ago, Heard made some quite heinous and disturbing. About 6 years ago, Heard made some heinous and disturbing, brought these certain criminal acts against me that were not based in any species of truth. Depp also testified that after the public became aware of the restraining order, the bad news about him was multiplying throughout the media, throughout social media as well. Even Depp's expert, Doug Bania, who Depp retained to analyze the impact of the allegations on Depp's reputation, could not say that Depp's reputation or public image were affected by the op-ed as opposed to the events of 2016. I mean, tomato, tomato at this point, like tomato, tomato. Because Depp improperly was allowed to suggest that the jury could award damages based on statements Heard made prior to the publication of the op-ed, and the jury was not informed of the outcome of the UK proceeding, supra section 3A2, the jury damage award is wholly out of proportion to the reputational damage Depp actually could have sustained as a result of the op-ed. It is clear from the size of the compensatory damage award that the jury intended to award damages not just for the op-ed, but for all the negative publicity that Depp had received since Heard first accused him of abuse in 2016 and continuing after the UK judgment. That is an impermissible basis for damages in this case. At a minimum, the jury's excessive damage verdict should be reversed and the case remanded for a new trial on damages. Conclusion: for the foregoing reasons, Heard requests that this court reverse the judgment against her and either enter a judgment for her or dismiss Depp's claims without prejudice, or B, remand for a new trial. Signed, J. Ward Brown, Axelrod of Ballard Spar, and Rottenborn, and a different Elaine, not Bretta Hoft, Elaine McCafferty, Woods Rogers Venter, attorney for the appellant. Here's a certificate that it was sent to Brown Rudnick. There's Ben Chu, there's Camille, Wayne Dennison, and 55 pages certification. Whew. Well, what an early Christmas present to us all. I think my face says it all. We had 11 golden nuggets, 1 diamond nugget, and 1 moon rock encrusted nugget. We had admissions that she wrote it. We had admissions that there was no sexual violence. We had admissions, like, oh, but for admissions. The lies, the more you continue to try and perpetuate them, begin to unravel themselves. You don't even need to do anything in order for it to happen. Hold on a second. I'm going to do this just because, oh, that was a marathon. A skew tie. That's how you know you're done with work. So what do we have? We have 3 central arguments that are broken down further. Some of the better arguments, as I mentioned, really are towards the end. The incongruence of the verdicts is probably, in my opinion, the biggest thing that they have, because the jury was just so confused. But for some reason, they absolutely positively did not capitalize on it, and I don't know why. Thank you for the super sticker, Mr. RN. This is definitely unprecedented. I really anticipated a lot more First Amendment argument, but I guess they realized that there is no case law to support it when they started doing their research. So remember when Amber tweeted the original tweet after her trial, which is this right here. The disappointment I feel today is beyond words. I'm heartbroken that the mountain of evidence, again, they keep referring to this mountain, but nobody can show it. I'm heartbroken that the mountain of evidence still was not enough to stand up to the disproportionate power, influence, and sway of my ex-husband. How about evidence and facts? You ever tried that? I'm even more disappointed with what this verdict means for other women. It is a setback. It sets back the clock to a time when a woman who spoke up and spoke out could be publicly shamed and humiliated. It sets back the idea that violence against women is to be taken seriously. From truth-sayers, no, it doesn't do anything. For liars, absolutely it does. I believe Johnny's attorneys succeeded in getting the jury to overlook the key issue of freedom of speech, which I did not even mention in my appeal, except for literally less than 1%, about half of 1 page, and ignore evidence that was so conclusive that he won in the UK. Again, no relevance to the US. I'm sad I lost this case, but I'm sadder still that I seem to have lost the right I thought I had as an American to speak defamatorily and openly. Sorry, to speak freely and openly. But you're allowed to speak freely and openly so long as you don't lie and don't defame someone. So, and there's more, but there's no point. I just wanted to make sure that we're all on the same page. That's what she said. First Amendment principles protect me. And in her brief, she mentioned First Amendment principles for about 0.7%, 0.7% of the brief. Anyway, you all, I am tired. I'm going to go take a nap. So tomorrow, don't forget, Fair and Balance is going to be joining me. And on Wednesday and Thursday, we have another special guest on Thursday, which is a secret for now. And then Wednesday, if I get a chance to get my hands on that beautiful brief from California, I will be doing that. So thank you all. Don't forget to like this video, comment below, subscribe to the channel. I love every single one of you, and I will see you all in the next video. Bye, everybody.